Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. Welcome to the Fourth Circuit. We'll begin with our case 22-4654. Counsel, we're happy to hear from you.
Good morning, and may it please the court. The district court erred in two ways in this case, both of which require reversal. This morning we'll begin with the sentencing argument and then move to the Rule 11 error. This court's precedent is clear. Where an individual makes non-frivolous mitigating arguments in support of a lower sentence, the court must address those arguments. And it must do so in a way that makes it patently obvious on the record that the court has considered those arguments.
What case says that? Patently obvious. That's a pretty strong claim.
Judge, I believe that is from Blue or Ross. I don't have the citation.
We use the words
written.
patently obvious?
This court has used the term patently obvious, yes, Judge.
Okay, thank you.
And the district court here failed to address Mr. Solis's three non-frivolous mitigating arguments. One, his young age at the time of the offenses. Two, his lack of criminal history. And three, his expressions of remorse. In fact, when the court issued its sentence—
Is your position, counsel, that that the district court, as I understand our law, it might be broken into two obligations, one to consider and one to explain? Is your position that the district court did neither, or one, or what?
Judge, it's our position that this court has held that where a court can establish that it considered arguments, one way is by addressing them, another way is by engaging counsel in conversation, and this court did not engage in conversation, so it's unclear on this record if the court considered those arguments.
So your position is the court didn't even consider the arguments?
That is correct, Judge, yes.
So can I ask you, just as a factual question, am I right that there was no sentencing memorandum submitted by the defense in this case?
There were objections, but there was no memorandum.
So the only statements made by the defendant or defense counsel in support of a sentence are what was said at the sentencing hearing?
Yes, Judge.
Okay. And so the only thing that could have triggered a district court's obligation to respond is what was said at the sentencing hearing?
Yes, Judge,
Okay.
That is correct. And when the court issued its sentence in this case, it actually addressed every 3553A factor except criminal history, which Mr. Solis's arguments went to. That was error based on this court's precedent.
Let me ask you this. Before he imposed the sentence, he told the judge, told the lawyers what the sentence was going to be, and asked them if they had any legal reason why that sentence should be imposed. And nothing was said about the omission of the explanations with regard to these mitigating factors. Does that change the standard of review for us when the defense attorney is given an opportunity to object? And I would presume this is a legal error, that it's not been explained. When the judge gives the defense attorney the opportunity to tell him of any legal errors and he passes and doesn't mention it, does that change our standard of review?
No, Judge, it doesn't. This court in Lynn established that the issue is preserved where counsel asked for a lower sentence.
But in Lynn, there was no opportunity, no specific question to the defense attorney. Do you have any legal reasons? And he says nothing. What, doesn't that, what I just asked you, do you think that would have changed the standard of review for us?
Judge, based on this court's holdings and on this record, no, I don't believe it changes the standard of review. Had the court asked, did I miss any of your arguments, then perhaps we would be in a different position, but that wasn't what was done here.
Yeah, so let me ask.
Go ahead. Let me just follow up. How can the judge fix his mistake? In other words, if the district judge has just forgotten to specifically explain a mitigating circumstance, how does he correct that mistake if he's just forgotten? While the matter is before him, instead of having to go through all the time and expense and taxpayers' money to come up here and litigate it, there's the opportunity that he's given the defense attorney and the government to correct any mistake he might have made, something he might have forgotten. Why doesn't that change the standard of review?
Judge, again, based on this court's precedent, the issue was preserved, so we are here on the harmless error standard of review. I understand the court's concern, and certainly if the court had asked, are there any arguments that I missed, maybe we would be in a different position. And
Maybe.
Would that
certainly,
assume that, what position would we be in if that question had been asked? You say this is not specific enough, but let's say it was as specific as you just articulated. What would be the situation then?
if counsel had not responded, reminding the court, or if the government had not, well, that's not correct. If defense counsel had not responded, reminding the court of his arguments, then certainly we would have, there would certainly be an argument that we had waived those arguments.
So that would be the issue, waiver, if presented with it. And if that's right, our question is whether it has to be as specific a question as you mentioned, or a general one like Judge Traxler pointed out was done here.
Judge, it's my understanding based on this court's precedent that yes, that the court's question of did I miss any legal issues, that did not cause counsel to waive any sort of arguments. Based on this court's precedent, we are here under the harmless error standard of review. And because we're here under that standard, and the government's not contested that we're here under that standard, the government cannot establish that the error was not harmless.
So you said there's also two strands. Judge Caldbaum raised two different areas of our precedent. It also strikes me there's a separate question too, which is, first, independent of what a defendant says, the district court has to adequately explain its sentence, right? So even if the defendant says nothing at all, the district court has to give a sufficient explanation of why it's giving the sentence, right?
Yes.
And then there's the second obligation to respond to arguments made by the defendant, right? But I guess implicit in that is the district court, that second obligation only attaches to arguments the defendant actually makes, right? The district court doesn't have to think up arguments the defendant could have made and then rebut those arguments, right?
Yes, Judge.
So can I ask you that what worries me a little bit about this case is, and that's the reason I started by asking about the sentencing memorandum. I sort of have the feeling that the district court here could have been of the view, what is gratuitously asserted can be gratuitously rejected, because you phrase it as he made arguments about age and remorse and mitigation. And if all I have to go on is the sentencing transcript, these are all pretty thin, right? I mean, remorse is the defendant allocutes and says, I'm sorry. I think I can take judicial notice of the fact that an enormous number of criminal defendants allocute and say, I'm sorry. So I'm a little skeptical about whether that triggers an obligation to respond to a remorse argument, because it's going to suggest that every district court has to respond to a remorse argument. And then I see what defense counsel says about age. He says, stands before the court as a young man. And these sound like factual statements about the defendant, not an argument. He was really young and stupid, so you should be nice to him because you know what I'm saying? Like, these feel like very perfunctory arguments, and it seems a little bit weird to say that defense counsel can just say he's a young man, and now the district court has to go through a full dress response to, as if defense counsel had filed a 10-page sentencing memorandum pointing out that he was 17 years old and brain development and all, like, right? Like, I feel like we'd be in a very different position if there'd been a 10-page sentencing memorandum about age. But here, I just got defense counsel saying he's a very young man. That feels pretty perfunctory to trigger an obligation to respond by the district court to me. And I want to give you a chance to respond to that.
Thank you, Judge. It is certainly an abbreviated argument. It is certainly a very short argument. But this court has not placed any boundaries around or limits around what qualifies or does not qualify as enough to satisfy whether something is an argument. In fact, this court has said that where you ask for a lower sentence and then offer reasons for that lower sentence, that is an argument. And these were, again, short, yes, but they were certainly arguments. This court has also said that response
Well,
from
hold on,
the
does
court.
defense counsel ever, I'm literally looking at everything defense counsel said. Defense counsel says nothing about remorse that I see. That's just the defendant when he allocates.
That's correct, Judge. It is just the defendant. The counsel does not say that. And the court did not have to provide a lengthy response, but it did have to establish that it balanced or weighed those particular reasons for a lower argument, or for a lower sentence rather, when it was issuing the sentence for Mr. Solis.
Let's talk about that. The district court said it considered all the, let's take remorse out of it for the sake of this question. The district court expressly said it considered all the 3553A factors, and those encompass age and criminal history. Do you agree with that?
The factors do, yes,
Yeah,
Judge.
okay. And I grant you that the court didn't mention those specifically, mentioned the factors generally. But then the district court goes into the reasons it had for explaining the sentence in detail. I mean, he talks about deterrence and the nature and circumstances. He just doesn't mouth those categories. He gives detail. He says, I'm a father, you're a father, I understand why you'd be threatened. This is not a situation where it's as if the district court was playing on its phone while this was going on and then issuing a sentence later. It seems to be an engaged process. So I wonder if the district court had said, I've considered the 3553A factors, we can acknowledge they include age and criminal history. I think they're outweighed by these factors. I mean, you probably wouldn't be here, right?
That's correct, Judge.
And so we're here because he didn't say they're outweighed by. Isn't it obvious in the context that that's what he thought?
No, Judge, that's the problem. It's not obvious in the context.
Why not? If he says, I considered all the factors, those include age and history, and then he says, I think he says, I want to talk about the things that are most important. That even adds something else, like if these are the most important, there's something that's less important. I mean, don't get me wrong, I grant you could say a few more and it would be absolutely clear. But we have case law that says context can inform us. It doesn't make sense to have that if you have to recite the words. Why isn't that enough?
It's not enough, Judge, because sentencing is not a binary. This court recently said that in Shields. And what that means is that had the court explicitly considered these factors, then it could have moved the needle a bit on where he fell in sentencing. Had the court, because as Your Honor points out, he did say, I'm a father as well, things like that. And had the court established that he considered those mitigating arguments, then it could have moved the needle on sentencing.
Why isn't it enough, like I said, I asked this question earlier, there's consider and there's explanation. And I don't mean to belabor this, I think I understand your point, but so you don't think the district court can satisfy the consider requirement or obligation by referring to the 3553 factors generally?
No, Judge, and this court's precedent has established that the court can't just say, I've considered the factors, it has to actually address the arguments. And
Well, I agree, I'm not suggesting just mouthing, I've considered the factors and announcing a sentence, but, I guess I'm just breaking up the consider versus explanation, so I'm probably, you've answered that, I understand your position.
thank you, Judge.
Can I ask you on the preservation question, do you have any other support for the argument this is preserved other than Lynn? Because I'm looking at Lynn right now, and it does not appear that, at least in our opinion in Lynn, there was anything like what happened here, where the district court said, is there anything I missed or should have? There's nothing in Lynn that suggests that happened in Lynn.
Judge, right now, I cannot
Okay.
cite a case for this court.
Sure.
I cannot.
Totally. Can I take you to the other question I know you wanted to address for a moment?
Yes, Judge.
Is your argument the district court had to mention the possibility of consecutive? It seems to me there's two slightly different claims that are getting sort of mashed together in the briefings, and I just want to make sure. So one is that a district court has a legal obligation to tell a defendant that sentences can be imposed consecutively. The other possibility is, irrespective of whether there's that obligation, The magistrate judge here just misleadingly suggested that this person's overall exposure was capped. Which of the two arguments, or both, are you making?
It is the latter, Judge. We are saying that the magistrate judge incorrectly informed Mr. Solis that he was facing 10 years on these charges, indicating both counts.
So in other words, to rule for you, we would not have to hold that a district court has to notify people of the possibility of consecutive sentencing.
Absolutely not,
Okay.
Judge. No. That would be best practice, but that is not required by this court. And that Rule 11 error, the magnitude of that error is literally double. It's 20 years. And Mr. Solis had a viable necessity or self-defense argument at trial on that second count. During cross-examination of Christopher Silva, the individual who was shot, there was some impeachment evidence that came out. And it really shows that the government's case is not as strong as it argues it is. And had Mr. Solis known, he would have gone to trial. I see that my time has expired. Thank you.
Wait just a second. Could I have indulgence of you two to ask some questions?
Sure.
The first questions I have to do with the question of the maximum of 10 years. You say in your brief that trial counsel thought 10 years was the maximum for both counts combined. And do you still maintain that position?
Judge, it appears on the record that that is what defense counsel believed.
Then why would he be arguing that these offenses should be treated as continuing offenses, one continuing offense, where the maximum is 10 years? Why, in other words, if he thought the maximum was 10 years, why would he be arguing his continuation theory?
It's my understanding, based on the record, Judge, that from both the written objection and then the argument at sentencing, that counsel at the trial level believed that there was an apprendi issue that would cap the sentence at 10 years. And in addition to that, based on an incorrect reading of the law, he believed that the counts could not be run consecutive because of a case that they discussed in the record at the trial level. I believe it was Levesque.
But when the judge was talking to counsel and they were arguing this continuation theory, the judge explained to him how you had to stack these things, and he as long as the guidelines call for a sentence between 10 and 20 years, they would be stacked, and he said, that's correct. So I still don't understand why you throw in the trial counsel under the bus in this particular case, because it seems to me it's clear he did know that 20 years was the max. That's not saying the defendant knew, but you said that the lawyer didn't know, and I just don't understand that.
Judge, we can certainly agree that mid-sentencing, counsel changed his tune about what was, or he then agreed with the court about what the law permitted. But certainly leading up to that, we didn't have any indication in the record that he understood that the maximum was actually 20 years rather than 10 years.
Okay, my next question. In the third prong of plain error analysis, is the question what the defendant would have done at that time of sentencing, or is the question what he would do today?
Judge, it's my understanding that it would be at that time, had he known the full picture, then his decision-making process would have been fundamentally different. His strategic decision-making process would have been fundamentally different at that time.
And I agree with that, but I think it conflicts with Lockhart, where Lockhart let the appellate lawyer tell them he will go to trial if you vacate his sentence, which would indicate to me that the en banc court in Lockhart said is saying implicitly, the question is, what would he do now? And I don't understand that, but.
Judge, if you want to make it what is it now, we will certainly accept that.
I'm sure.
But if the court, either way the court looks at it, in this situation, Mr. Solis was in a position that would have been strategically very different.
Okay, what is your best case to show that this alleged error, again, talking about the 10-year maximum, was plain?
Harrison, actually, Judge. In that opinion, this court said that the court must make clear the statutory maximum on each count. And here, the magistrate court just did not do that. It said 10 years on these counts, indicating both of the G5 counts together.
Who wrote Harrison?
If Your Honor will indulge me for a
No,
moment.
I can look that up. That's all right.
Okay.
I think it was me, by the way. Your argument also in your brief says that there's no evidence the defendant got correct advice outside the courtroom. After Lockhart, does that matter? And the reason I'm asking that, in Lockhart, the defense counsel had put on the record at the time of sentencing, I told him about this. So when he pled, he knew there was a statutory maximum. And the Lockhart majority disregarded that, said, well, we have no way to judge the credibility of defense counsel at the time. That's kind of a surprise to me. But my question is the point you're making in your brief really relevant after Lockhart?
To the extent, again, Judge, to the extent the court wants to say that it is not relevant, it certainly doesn't hurt our case. To the extent the court does want to consider it, it certainly weighs in our favor for a remand, for the sentence and plea to be vacated and remanded.
All right, my next questions have to do with the failure to discuss, the judge's failure to discuss the mitigating factors presented to him. Do the lawyers in the case, whether the government or defense, have a duty to the court as officers of the court to remind the judge that he has not directly addressed issues that the law requires him to address? And Ms. Ray, you better listen to these questions because you're going to get the same ones. Do the lawyers have a duty to the court to help the judge, correct the judge if he has omitted, possibly, probably, by mistake, to address these issues? What obligation do the lawyers have who are there before him with the opportunity to correct the mistake to do so?
Judge, based on this court's precedent, there is no obligation, certainly from defense counsel, in my understanding, not from the government either. If the court changes its mind on that, we would ask that the court make that forward-looking, because that was not the law at the time that Mr. Solis was
So you don't
sentenced.
believe there's any obligation?
Not under the current state of the law, Judge.
Sometime go read Vaughn, which is a United States Supreme Court case where Judge Souter deplored the fact that a lawyer, particularly a defense lawyer, could see an error occurring, do nothing about it, just keep it in their pocket, wait and see if the sentence the defendant gets is one they like or can live with, and if they don't, then they've got an instant ground for appeal. When there was a perfect opportunity there while they were in front of the district court to get this issue cleared up. So I just was curious as to what your response was. And I think I've already answered the other question. That's all I have, and I appreciate my colleagues' indulgence.
Thank you, Judge. If there's no further questions.
Ms. Ray?
May it please the court, Amy Ray for the United States. Sort of reflecting on the last argument, I think I'll begin with just a couple of points about the sentencing issue and then perhaps turn to the plea colloquy issue. On the sentencing issue, Judge Heitens, you have identified what I think is a challenge for us, at least on the government side in these appeals in a number of cases. And this case is perfect. I would invite this court to consider what constitutes an argument. This was 11 lines in a transcript. And in Lynn, we know that simply making a point isn't enough. And I would invite this court to hold that an argument requires at least a nexus, an argument of a nexus between a fact and a 3553A sentencing factor. So he's young. There's no dispute about that.
So Ms. Ray, before we get to the merits of the argument, can I just,
Sure.
I assume you agree with me that forfeiture can be forfeited?
Yeah, I do agree with that.
And I'm looking at your brief.
Yeah,
You
didn't
never
argue.
once argued that this claim isn't preserved, right?
Did not.
So you've 100% forfeited a forfeiture
I
argument.
have in fact forfeited the forfeiture argument. That doesn't mean this court cannot address it.
Sure, but
And
you-
yes,
the government has no right to insist that we do it because
No.
I believe I've written a case that says forfeiture can be forfeited.
Absolutely. I do not contest that. We did not make that argument. I noticed, look, Judge Whitney does this in every sentencing. He says, is there any legal reason why I cannot impose the sentence? And I now think I probably should have argued that that would trigger a plain error standard of review in this context. The reason that I haven't done that in the past was I sort of interpreted that to mean more of a legal error with the sentence, like a statutory range kind of error.
In fairness, that's probably how I'd read what he said as well.
But, I mean, that said, I will say, I've been up here, and my colleagues have been up here numerous times, and it is maddening, frankly, to see defense counsel stand in the courtroom and not say to a judge, "Judge, you didn't mention this." And it's likewise, I have encouraged my colleagues to do the same thing.
Okay, but in fairness, it would also be incredibly easy for the district court judge to say, which I know is a fact that district judges within this circuit say,
Yeah.
have I not responded to any of your arguments? There are
Absolutely.
district judges who do that in every sentencing case.
Yes, and I think in that case, there's a waiver, and our judges so far have not done that. I would appreciate it if they did, but they haven't. I guess the bigger, for me in this case, because it was simply a statement, he's young, I don't think the remorse counts. He's young, he
But
has no.
why? Because the defendant said it?
Yeah,
not
I
defense
mean, I just don't think that can be characterized as an argument. It wasn't one that was, it was simply a defendant in allocuting and saying, "I'm sorry," or "I'm
Ms. Wright,
remorseful."
While we're talking about things people should do,
Sure,
government lawyer's there in front of the
Yes.
judge and hearing everything that's being said. And if a mitigating factor should be addressed and it's not, then it comes up here to be reviewed for harmless error,
yeah,
which means the burden's on you
yes.
to establish this right. So I don't understand why in the world, let me rephrase my question,
No problem.
where it sounds more legal. Don't they have a practical responsibility when the government lawyer's there before the judge to make sure that that plea's done right, and make sure that the judge addresses every non-frivolous argument before you leave the courtroom and while everybody's there? I mean, I don't understand why government lawyers don't view that as part of their responsibility.
I'll respond to that in two ways. First of all, just with respect to this case, I don't think it's fair to even characterize these as arguments that the district court
This was
failed to.
what kind of case?
In this case, because of the way, I don't think those were arguments that the district court failed to address. And so I think in this case, maybe the government lawyer understandably did not do that.
But shouldn't it be done the best practice, do it in every case?
You know, I will say this, Judge Traxler, I have wondered the same thing and talked with colleagues about this question. It's a little more sensitive, I think, for a trial lawyer who appears in front of a district judge all the time to say, "Judge, you might have missed this, you might have missed that."
But that goes, that goose and gander, right? You can't have it both ways. If defense counsel is supposed to, if we're gonna say the government can't realistically be expected to do that, it's a little weird to say defense counsel has to do it. And if we're gonna, I just don't understand why the government's obligation is less than, I mean, I agree, there are district judges I would never want to interrupt to do that, but it seems to me that if we do that, if we're gonna start going down that rabbit hole, the defense counsel and the government are held to the same standard.
Okay, I'm not suggesting that defense counsel has a legal duty to jump in and say, "Judge, you didn't do this." If the defense counsel is asked, I think they do. I think it would be, the difference is the defense attorney represents the defendant. If the defense attorney actually thinks that if the judge has missed a point, the judge would impose a lower sentence, that defense attorney has a much greater incentive to say to the district court, "Your Honor, I think you forgot that I said he was young." And so that is a difference between the implicit obligation of a defense attorney and the implicit obligation of a prosecutor who simply needs to do their best to make sure that the judge actually sticks with the sentence, maybe that the prosecutor thinks is right. But I think,
Go ahead.
go ahead, that I do think that in this case, the issue is, these don't constitute arguments. They didn't tie this, and I would refer the court to this court's recent decision in Davis, where the defendant, and this was just in the last couple of weeks, February 27th maybe, where the defendant talks about adverse childhood experiences and says, "I've had all of these ACEs." And he presents a little bit of research, but does not explain why the court should believe that his ACEs, the ACEs that he experienced as a child, are mitigating. And that's what this court should require for something to constitute an argument, that there is a connection made with the 3553A factor. In this case, Judge Whitney said, I considered all the factors. That included criminal history, it included age, and the defendant was right in front of him. It was obvious that he was young. Judge Traxler.
Thank you.
Sorry.
Going back to the question of the responsibility and
Yes.
relevance of the government's lawyer calling omissions to the judge's attention, I would simply suggest you consider telling the lawyer in front of the judge, why don't you come up here and why don't you write the brief? And then you come up here and you argue the case, and then you explain to the judges why you're up here and why we're going through all this when the problem could have been solved.
Fair point, Judge Traxler. And I will tell you that yesterday there was an argument that Ms. Hester presented on behalf of the defendant. One of my colleagues made the argument. Judge Wynn was pretty strongly making sort of the same point. Why aren't the judges doing this? So I'm going to go back and have conversations with each of our district judges, I hope, just as, sort of, hey, this is what might be helpful. There's also a case from out of South Carolina that's going to present this court, I believe, with the question of the judge asks specifically, is there anything I have not mentioned, and whether that's waiver. So I think these things are starting to come to a head because we have had so many of these appeals, and all of us feel a little bit frustrated.
So
I appreciate it.
how would you characterize the consequence of a defense lawyer being given the opportunity to raise an objection about an omission? Does that change our standard of review, and if so, to what?
Yeah, to me, that's waiver. I think that's waiver. If the judge says, have I missed anything? And the defendant stands silent. But there's going to be an argument. I didn't research that for this particular argument, but to me, that's waiver. But at a minimum, it's plain error. At a minimum.
So, make sure I'm understanding. Are you
Sure.
drawing a distinction between a question from the district court that have I made any errors and a question, have I omitted any of your arguments?
Yes.
So what's the effect of one versus the other?
So in this case, I didn't argue plain error, so I want to be clear about that.
I'm just talking about
To
general.
me, the difference is, if you simply say, is there any legal reason this sentence can't be imposed? That would be a forfeiture, because it's not a very specific question that asks the defendant to say. In other words, a
It
defendant.
sounds more like, have I exceeded the statutory maximum, or have I?
That's how I interpreted it, Judge Heidens,
Right.
which is why I didn't make the argument. But I would suggest that in what waiver is the relinquishment of a known relinquishment of a right. And when you say, is there anything that I have omitted, and you stand silent, I think you have relinquished your right to then come up to the court and say you didn't say this, only because it was such a specific question. I think it's hard, it's a close call. That's just my opinion.
Can I take you back to the?
Go ahead, Judge.
So I understand the district court judge in this case twice said the words, I've considered all the 3553 factors.
Right.
Look, on balance, better to do that than not. But you agree that is not a get-out-of-jail-free card. You cannot just say the words, I've
Yeah.
considered all the 3553 factors, and your sentence is procedurally reasonable.
Yeah, absolutely.
Okay.
Yeah, no question.
So what role do you think it plays that, like, the district courts sure seem to think that saying those words had some magic effect. What effect, if any, do you think saying those words has?
I think that actually in this case, I will say, kind of going back to Judge Quattlebaum's, there's two sort of duties, right?
Uh-huh.
So in the adequacy of the explanation, you can't simply say I've considered all of the factors, because you have to say more and explain them, and Judge Whitney did that. In terms of this case, where you have somebody just saying, I'm young and I don't have any violent criminal history, and the judge says, I think it serves the purpose of saying, I have considered history and characteristics.
And that's not what he said.
No, he said all of them. So that includes history and characteristics. So he is saying, I've considered history and characteristics. He didn't say it explicitly, but that's included within the context. My point is, where he hasn't.
Counsel, sorry to interrupt.
Sure.
But
Please.
it relates to that. Doesn't the additional language that the district court used, that these are the most important,
Right.
add some flavor to this still not calling out age and criminal history by name.
Right.
But, suggesting these others are more important, it's gotta be more important than something else.
Yes, I think in this case that was important, and that, I mean, it's just helpful. I don't think this is that close of a case in terms, because he didn't make arguments. I will also say, I think it's a really.
So, I understand your position that this doesn't rise to the level of argument. But, while perhaps not developed like it could be, as I recall, the district court, right before those comments are made, the district court asks a question about your arguments. So district court says, I'll hear your objections, and then it's mentioned. Now, again, I get it, you could be more specific, but just sequentially, one might conclude it's an argument. I'm not asking you to concede that, but
Yeah,
assume
I
we
won't.
think it's, fair enough, but if we disagree with you, I mean, we still, aren't the points you're making, wouldn't they apply even if it was a full-fledged argument?
Yes, and I was going to make the further point that this is a perfect case for harmless error if it were, if this court were somehow to hold that this was an omission that was a procedural error.
And how do we do that in light of Shields, the recent case? Could
Sure,
you
well,
explain?
Shields doesn't really change anything.
Right.
And you have Bullware, you have a bunch of cases, actually, I was reviewing in preparation for this, there's a number, Bullware may be the only published case. There's a bunch of unpublished cases, Eads and Valentine.
So let's focus on the published cases.
Sorry?
Let's focus on the published cases.
Yeah,
Why do
happy
you
to,
think?
happy to. But the point in Bullware was, are the arguments at all strong? Age and a lack of violent criminal history when he has taken a gun and point blank shot at somebody and within the month before shot at somebody else, that's not a very strong argument. Age isn't a particularly strong argument because it can weigh.
It makes sense to me why the strength or weakness of an argument would matter for harmless error.
Yeah.
Just kind of logically.
Right.
But does that, I agree Shields doesn't change the law in terms of harmless error. But if you have a case where there was a good argument that the issue wasn't even considered,
Right.
then how do you know whether the strength of it would make a difference?
So I think that, let me say this, these cases are hard because they're all so fact intensive. And in my at least review of them, trying to wrestle and grapple with what's harmless and what's not and how does that come. The way I finally came down, my own assessment of it, honestly, was the explanation, did the judge make pretty clear that it was certain about the sentence, he or she, about the sentence that was going to be imposed? And did the reasons given in some way sort of encompass or, rebut on, at least implicitly, the arguments that weren't made? So here in this case, he's arguing that he has a low that he's not violent, basically. He didn't have violent criminal history. And the judge focused very heavily on the violence of this offense. That was the reason given. So I don't think there's any strong argument that argument would have made a difference. And the fact that he was young he couldn't have ignored that. The defendant was standing right in front
What
of him.
age was he?
He was 22 at the time of sentencing, I think. So 21, 22.
So I have one more question about this
Yeah.
topic, and then I have a couple about Rule 11.
Sure.
What is your best case to support the proposition that a defendant has to connect their non-frivolous arguments to one of the 3553 factors? You say that
Lynn.
in your brief, but what
Yeah.
case says that?
Lynn says it. I believe Arbaugh, Nance, I don't remember which. There are others after Lynn, but Lynn kind of has this paragraph where it discusses, where the court talks about how, points marshaled in favor of something are not really arguments.
Okay.
And I would say, Judge Heitens, in all candor, that it's not as clear as I think it could be, which is why I'm inviting this court to make it clearer.
Fair enough. Okay, moving to Rule 11. So
Yes.
you heard your friend on the other side say the argument they're making is not that a district court has to tell someone about consecutive sentencing.
Right.
So I'm looking at the transcript, right? This is JA 20.
Yep.
Quote, "It sounds like the maximum penalty for these offenses would be 10 years of imprisonment." I'm just going to tell you, I would interpret that as saying the total maximum is 10 years. And you
Yeah.
agree that if I understand that, that's legally wrong when the district court, if what the magistrate judge said is the most time incarceration you could get is 10 years, that would have been a legally incorrect statement, right?
I agree with that, but I think it's really important that this court can't read what's on page 20 without reading pages 17 to 20.
Okay,
And
when I
I'd
read,
like to-
when I read pages 17 to 20, what I conclude, in all candor, is that not a single person in the courtroom understood what he was charged with or what he was facing, because there's all these colloquies, and
Oh.
people are like, I don't know what's going on here.
Judge Heitens, with all due respect, I strongly disagree with that. This was one of the most experienced criminal defense attorneys from the Federal Defender's Office. He knew exactly what time he was facing.
Okay,
And those
so-
colloquies, if I may,
Sure.
it was a short, it wasn't a side conversation. Here's how it went. Mr. Hess, prosecutor, tell me the maximum.
Right.
And by the way, you're pleading to 2 counts of the same offense. What is?
Okay, I'm just literally looking, you said
the-
17 to 20. I'm looking on 17. No
Yeah.
one says a single thing relevant to this question on page 17.
Yes, in my opinion, Judge Heitens, he says.
Because it says count 1 and count 2.
Yes, because he's identifying early on that there are 2 counts of the same offense.
Let's assume I'm not persuaded by that.
That's fine, that's fine. I respect that, obviously.
Okay, so what's your next best argument?
So,
Why?
no, but if I could just go through this. So he says repeatedly, you are pleading to 2 counts of the same offense. And then he says, Mr. Hess, what is the maximum penalty for that offense? And he says the maximum term of imprisonment is 10 years. Then he also
We're on page
notes-
19?
That is on page 19.
So then Mr. Hess says a whole bunch of things, and then the next words the district court says are, that's not right.
No, yeah, let me.
The next thing the court says
Judge
is,
Heitens.
no, I just don't understand how the defendant, when the government says something and the court says that's not right, how the defense like, well, I'm not just going to take the prosecutor's word for it, because the court literally just said what the prosecutor just said was not right.
Okay, what the prosecutor said, though, was the possibility that he could face a higher sentence, a mandatory minimum of 15 years. And it wasn't, he said a whole lot of things. He simply said, by the way, the prosecutor who was actually handling the case, Chris Hess was stepping in for the prosecutor for that particular colloquy, said she wants the court to know that because this is a 922G case, it could be, Armed Career Criminal Act could apply if there's something we don't know. And then the defense attorney says that doesn't apply. The court says that's right. So it wasn't, at no time could Mr. Solis conclude that he faced any time less than 10 years in prison for each of these offenses, because he was told, you're pleading to 2 counts of the same offense, and that colloquy only talked about whether it was a mandatory minimum of 15, not that it could ever be less than 10 for each offense. Then the court says, yes, it sounds like the maximum for these offenses. And if you take that in isolation, I grant you. But I don't think leading up to that, because he repeatedly says you're pleading to 2 counts for the same offense, and they each carries 10 years, that's what the prosecutor says. But if Your Honor disagrees.
Let's posit that I do.
Let's posit that Your Honor disagrees. I think our argument on whether it affects the substantial rights is very strong.
You're just giving away clear obvious?
I'm not. I don't think it's clear or obvious, but if Your Honor thinks it's that clear that he didn't do it, then I'm just gonna jump to the prong of plain error analysis that I think is even stronger. Judge Quattlebaum, it looks like you might have been about to ask a question.
No, you go ahead.
Perfect. So on substantial rights, we have Lockhart on the one hand, we have Massenburg on the other. And Lockhart does not overrule Massenburg. So I think I maybe just want to describe what's different about this case. Judge Traxler, I can see you're itching to ask.
I'm not sure what's left of Massenburg after Lockhart.
Yeah.
Because the elements that were important in Massenburg, 1, 2, 3, were listed in Lockhart, and that didn't answer the question for the Lockhart court. Then they went on and regarded 2 other factors. The fact that the appellate lawyer was saying this guy wants a trial, and then the court did its own analysis and determined, I guess, what he should have done, or what a reasonable person would have done. So anyway, I'm not sure what's left of Massenburg.
I think that, first of all, I argued Lockhart and didn't love the analysis. That said.
And yet, here we are.
And yet, here we are. And what is left of Massenburg is that Lockhart did not overrule it. So what I'd like to do is do a little compare and contrast and explain.
At a minimum, you have.
Oh, I see that my time is way over.
We're asking some questions, so you're fine. Thank you for
Thank you.
acknowledging it. But at a minimum, if we just look at Lockhart,
Yeah.
you have a minimal 4% effect on the sentence. Massenburg has a longer one, this has a longer one.
Right.
So even if we kind of, ignore Massenburg to the extent, Judge Traxler's right, there may not be much left. Taking Lockhart on its terms, you would argue that difference in sentencing, is that a difference?
That is, I'm going to identify at least 3 differences, okay? First of all, there were 2 errors in Lockhart that the court found important and in fact determinative. And the court never suggested in Lockhart that had that Ray Haif error not existed, that it would have not found that this, anyway, I'm going to get mixed up in the way I'm articulating this, but it found the Ray Haif error to be critical, that nobody in the courtroom understood the elements of the offense to which the defendant was pleading guilty. So that's one difference. The second is the one that Judge Quattlebaum, you just mentioned, which is the difference in Lockhart. If he did not plead guilty, all he was getting was 8 months, basically, a reduction of 8 months from 188 down to 180 by pleading guilty. In Massenburg, there was a 23% reduction if he pled guilty, and in this case, it's almost 30% reduction. By pleading guilty, and that goes to the issue of whether there's a reasonable probability that he would have pleaded guilty or would not have pleaded guilty, would have proceeded to trial in the absence of the error. So when we can see that a defendant benefited by almost 30% reduction in his sentence, then the question becomes, would any reasonable defendant not have pleaded guilty? Then the other issue was Lockhart did tell this court that he would go to trial. I just heard from defense counsel for the first time that Mr. Solis would proceed to trial. I don't think that that's, I think it's a strange day when a defense attorney can come into an appellate court and announce that this is what the defendant would do and tell us that that's evidence of what the defendant would have done then, when the defendant was told by the time of the pre-sentence report and asked, pages 44, 47 of the joint appendix, did you read this? It was interpreted for you.
It also seems really hard to square with Greer, doesn't it?
With what?
Greer, the Supreme Court's
yeah.
decision in Greer.
Sure, I think that's right, Your Honor. And I think that on what we do know is that he was told in the pre-sentence report, and he said he read it, reviewed it with his lawyer, never sought to withdraw his guilty plea. That was true in Lockhart as well. Judge Quattlebaum,
I'm just trying to see
Yeah.
where you're going. I may agree with you in
but
whether that makes sense, but that's the law. I mean, that's Lockhart.
But Lockhart doesn't say that that's an irrelevant factor. It just says that in that case, that factor wasn't enough. And I think in Massenburg, that was enough of a factor because the court considered it and said that that was one of the factors that it would reach the conclusion that he could not, he couldn't satisfy his burden. And the other case I would just refer this court to, and Your Honors are well aware of it, but in Hastings, look, if there's a tie on the substantial rights and whether or not a defendant would have pleaded guilty, the tie goes to the government. So he has the burden to show, and if we're not sure what he would have done based on the record, then this court cannot hold that there's a reasonable probability that he would have proceeded to trial. It wouldn't have made sense for him. He faced too much time, and the evidence against him was incredibly strong.
Judge Hyten, do you have any other questions? Thank you, counsel.
Thank you, Your Honors.
I'd like to start on the Rule 11 burden for us under plain error. We absolutely bear that burden, but this court has made clear, as has the Supreme Court, that that burden is below a preponderance of the evidence. It's not even more likely than not. It falls below that. And that reflects a bit of a humility on the part of appellate courts because courts understand that the record doesn't encapsulate every factor an individual may consider, and it doesn't account for what a jury could do. For example, in Lockhart, after this court vacated and remanded, Mr. Lockhart went to trial on a case the government argued was very strong, and he was acquitted. And here we have more on the record from Mr. Solis. We have that self-defense or necessity defense. We have that information from cross-examination of Christopher Silva that was.
I'm just making sure I understand the context of your argument. I'm sorry to interrupt, Jari. Is your position that on harmless error or on the Rule 11 colloquy about prejudice?
I'm sorry, Judge, I was unclear.
You may have said it and I didn't catch it.
It is on the Rule 11. It is
On
the plain
prejudice?
error.
Okay.
Yes, Judge. Correct.
Can I ask you then, what do I do with the fact that he got a PSR that said he could get up to 20 years and he didn't do anything?
That's certainly a factor this court may weigh. And
Feels like a
can
really
weigh.
powerful argument against prejudice.
Here's why it actually isn't as powerful in this particular case. When the court looks at the whole record, we understand a couple of things that were happening. First, Mr. Solis has less than a 4th grade education.
But he's got a
from the
lawyer.
US. Yes, Judge. With an individual like Mr. Solis with his demographics, he's not only relying on an interpreter, he's relying on his attorney to explain everything to him. And that is why the information from the district court in the middle of sentencing mattered so much. Because the information that the attorney was providing is, we'll say, unclear at best. But even if the attorney were clear with him.
Well, hold on. My attorney did not accurately summarize the pre-sentence report, which is why I pleaded guilty. It would be an ineffective assistance of counsel argument, right?
That is correct, Judge. What I'm saying is, and I'll be a little bit clearer with my words here. First of all, let me back up for a moment. The PSR cannot cure the Rule 11 issue. We know this from Goins.
Agreed.
Second, we understand that given this record, that at best it is unclear what Mr. Solis understood in general. But that PSR, even if he understood what that PSR was saying, the Rule 11 information from the court is so important because we understand that defendants rely on the judge to be the arbiter of the law.
Okay, what about the fact that it's sentencing? The defendant didn't say, wait, I thought I couldn't possibly get more than 10 years. What about that fact?
Again, Judge, that's where we look to the whole record and to the.
I am looking to the record. I've now cited the PSR and the sentencing hearing.
Yes, Judge, I understand that. But that moment came from Mr. Solis after the district court had accepted his plea and in the middle of sentencing when court and counsel were engaging
But
in
this is, it feels like when you would expect a defendant who was genuinely, this is precisely the moment you would expect a defendant who was genuinely confused to say something, which is like, wait. I thought I could never get more than 120 months, and now you just gave me more than 120 months. Doesn't that suggest maybe that he did realize he could get more than 120 months?
No, Judge, in this particular case, it suggests that there was information, but it doesn't suggest that he understood from the court that he could get more than 120 months. And that's particularly important.
But he did when he was sentenced, right? If at no other time before then, we grant your arguments up to the point the judge says, here's your sentence. He knows it then, right?
Yes, Judge.
And from that point to the end of the sentencing hearing, there's nothing to indicate any objection, surprise, or anything. Agree?
That is correct, Judge.
From the defendant, from counsel, for anybody. I think that's what Judge Heitens is suggesting. I mean, you say look at the whole record, but the beginning of, maybe your argument there's some ambiguity in the colloquy, but you then have the PSR, and then you have this other. So maybe if there's some ambiguity at the Rule 11, how does the PSR then the sentence not give your client every opportunity to say, hey, I'm going to do something different. This is not the deal.
I understand, Judge. I see I just run out of time. May I answer Your Honor's question? Thank you. When we look at the whole record, we see at the Rule 11 plea colloquy, both, I believe in the transcript itself, but certainly in the paper that Mr. Solis reviewed with counsel and submitted to the court, that it says that if he receives a higher sentence, he cannot withdraw his plea. So the information he had from the court was you cannot withdraw your plea if you receive a higher sentence than you understood that you would receive.
So your argument is he got some piece of paper, he understood that enough to know he couldn't appeal, therefore he was like, I'm not gonna say anything, or I can't withdraw, not an appeal. Your argument is he received a document that says if he enters a guilty plea, he can't withdraw it. And therefore, when he was told something that was different than his expectations, he thought, hey, I can't withdraw it, so I'm gonna be quiet?
The information before Mr. Solis in that moment did include that, yes, Judge.
Okay.
And unfortunately, we're always just left with the record. And the record indicates that there were trial defenses and that he pleaded straight up. And perhaps he would have pursued a plea agreement had he known at that time.
Thank you very
Thank
much,
you.
counsel. We'll come down and greet counsel, then proceed to our next case. Okay, our second case is 23-2089. Mr. Massey?
Good morning, Your Honor. May it please the court, Robert Massey on behalf of the appellant, Ruby Dog Holdings, and others. This appeal presents a fairly straightforward, fairly simple, single question. Does a covenant in a 1979 deed run with the land, or does it not? Stated another way, is this a covenant appurtenant, or is it a personal covenant? The 1979 deed in this case ran from Snowshoe to a company called a Boss. And its chain of title is a Boss to Whistlepunk to my client, Ruby Dog. Let's start with some general law. We presume in a deed that anything in the deed runs with the land to the grantee. That is the presumption.
What case says that? Literally anything in a deed runs with the land?
I'm sorry, that's the presumption.
What
That-
case says literally anything in a deed?
I'm sorry, I shouldn't have said literally anything, but the McIntosh case, the Mays versus Hogue case, says that there is a presumption in interpreting the language of a deed, an easement or a covenant, that when we start with an easement or a covenant, that it runs with the land.
Are you saying those are exclusive terms, easement and covenant?
The exclusive?
Yes.
Those are-
Exclusive of each other. Because my understanding was an easement was a form of covenant.
I'm sorry, Your Honor, they are. I was thinking easement more in terms of the right to traverse a piece of property, like a right-of-way was what I was thinking. But no, an easement and a covenant, or an easement and covenant, the presumption runs with the land. The countervailing presumption is unless there is clear language limiting a covenant, it is not interpreted as a personal covenant. The law is we look at the intent of the parties. That's the polar star. That's what we're trying to figure out. What is the intent of the parties? Now, first, You look at the deed, you look at the covenant, you look at the language, and you try to figure out what did the parties intend.
Okay, so let me ask you what
Sure.
I looked at and what the district court looked at. So I look at this deed and I see over and over and over again, it identifies specific things that bind successors and assigns. And I see over and over again where it says that certain things shall run with and bind the land. And then I look at the provision you're trying to enforce and I don't see either of those things.
That's true.
Why isn't the overwhelmingly obvious most reasonable interpretation of that is when they meant successors and assigns or run and bind with the land, they said it, and here they didn't say it, so therefore that's not what they meant here. That just seems like, both as a matter of plain English usage and as a matter of how we construe legal instruments, that seems like the obvious inference. If you say certain things over and over again in one place, not actually in one place, in 5 or 6 places, and then you don't say them here, the assumption is you didn't mean to say them here because you didn't say them here.
Well, I can think of 3 reasons.
Great.
First, the language bonds the land is a reservation. It's put in the deed as a reservation to the grantor. The law is pretty clear that if a grantor is going to reserve something to themselves and it's going to run with the land, you have to expressly so state. So that the language after the covenant that we're talking about.
Where is that? Just so I know where you're talking about.
That was the clause after the privileges or recreation clause.
Is it in the paragraph that begins, this covenant is made subject to these?
I think so.
Yeah, but hold on. That paragraph ends with a colon, and that colon is followed by a list. So it seems like, again, as a matter of normal English usage, that paragraph applies to what comes after it, not what was just said before.
That's correct.
Okay, so then the which shall run with and bind the land doesn't actually apply to the provision we're talking about here.
No, I agree. My point was, if you're using the language binds the land, that it's used expressly to reserve something to the grantor. That's why it's in there. But Mays versus Hogue clearly says you don't have to use the word successors and assign.
Oh, I agree. So if
Okay.
let's say counterfactually, this deed never used the words
Okay.
successors and assigns or shall run with the land. I think the presumption you're talking about could help you.
Agree.
But this deed does use those words over and over again. It's just not in these places. And I don't know how a presumption that would say what would this deed be interpreted to mean if those words weren't anywhere in the deed tells me how to interpret a deed where these words are all over the deed, just not in the place you want them to be.
Well, 2 more reasons.
Okay.
First, the law is you don't have to use the magic words.
I just said I agree with
Okay.
that.
But
But
more
when you use
importantly,
the magic words in one place, isn't the logical inference that you didn't mean to use the magic words in another place?
no, look at the privileges and the recreation covenant, the language that is used. As part of this conveyance, language that we normally use to convey something in a real estate transaction, Snowshoe Company covenants and agrees that all guests of any hotel or lodge constructed on the property. It doesn't say any hotel or lodge constructed by a boss. It just says any hotel or lodge constructed. So there's no limiting language. Again, you have to have limiting language if it's a personal covenant. No language
Well,
here that limits.
In
But
devil's advocate, I agree it doesn't say a boss, but
Okay.
your brief seems to suggest the notion of the question about whether it runs to a boss's successors is inseparable from the question of whether it runs to Snowshoe's successors, and I don't know where that notion comes from. When I look at this, it says, as part of this conveyance, Snowshoe, not
Right.
Snowshoe's successors and assigns, Snowshoe, and then it says these other people. So I don't see how the fact that the later purchaser's benefit addresses whether Snowshoe's successors are bound. Those strike me as different questions.
Well, at the time, if you look at it, Snowshoe is developing a resort. The resort is referred to in here. And this clause specifically says that it runs to any purchasers of residence units constructed on such property. Snowshoe and a boss both understood and intended that when the covenant was executed, it would run from Snowshoe to a boss and from a boss to any purchaser of a resident. The language.
No, again, you're conflating the benefits and the burdens in a way that I don't think is supported by the language of the deed. I agree the benefits run to the successors. I just don't see where it says the burdens run to the successors.
The burdens have to run to the accessors. There's no way to have the benefit run to people down the deed if it doesn't correspondingly.
That's not true at all. I can make a contract with you, and I can agree that my obligation, like, say I have a contract with you, and I have an obligation to pay you, and then you assign your right to payment to someone else. I still have to pay the person you've assigned your right to payment to. But that doesn't mean that, like, someone assumes but then I die, and it's sort of black letter law that people's personal debts die with them. My heirs don't have to pay that, right?
Yes, but that's a different
So it's
question.
totally possible to assign the benefits without assigning the burden.
But here you're burdening real estate. You're saying Snowshoe will allow people who enter onto their property to use lift facilities, to use their property. And they will continue to do that. So I'm saying that there's no way to interpret this except that if Snowshoe is promising, I as the owner will allow people to come onto my property under a license where I agree that if you pay X dollars, you can enter onto my property. That promise touches upon the land. That promise runs with the land. But more importantly, this was a Rule 12 motion decided by the court. In the pleadings, the allegation is that Snowshoe Mountain is a successor in interest to this entity and is bound by it. You have to assume that those allegations are true.
Those are legal claims. That's a legal, claiming that someone's bound by something is a legal claim. It's not a factual claim.
No, it's a factual claim that we alleged in the answer and counterclaim, paragraph 22, that Snowshoe Mountain was a successor in interest and bound by the terms. We also, if you look at
I'm sorry, counsel, but are you saying because you said that, we can't look at the deed and interpret it to determine whether or not it actually runs with the land or not?
No, Your Honor. What I'm saying is that the allegation in the complaint is that Snowshoe Mountain is a successor in interest and bound by the terms legally and factually. But also, if you look at the record, and I think it's in the appendix at 702, and I want to make sure of that, it was asked, how is Snowshoe Mountain related to Snowshoe Company? And they admitted in the record that Snowshoe Mountain is the successor in interest, acquired all the property interests and obligations.
Yeah, but that just begs the question of what the interest was that survived, right? I mean, that they are down the road, but that doesn't answer the question of what being a successor, meant legally. I mean, so anyway, don't we still have to grapple with the question that you've been, going back and forth with Judge Hyten's on, which is, what's this deed say?
Right.
That's the issue, right?
That is the issue. The language should be interpreted, isn't even interpreted, just applied as written. That's all I'm asking this court. That's all that we're asking below. Is that, one, the fact that there is no successors and assigned language in this clause is not evidence. The district court found that it was not.
I'm sorry, go ahead. Yeah. I'm in looking at this, I don't think, your argument seems to be, if you look at this particular paragraph in the deed, that's enough to show the intent. Is that, am I right about that?
That is my argument, with both sides saying that the deed is unambiguous. However, I will suggest to this court, again, it's a de novo review, that there is evidence that the parties intended this. Both sides intended this. The 1981 deed between Whistlepunk and...
How in the world does a deed entered years later tell me anything about what people meant years before?
Well, because the person who signed that deed, Mr. Bingham.
One of the people.
Right, and his role is actually key. Mr. Bingham was president of Snowshoe. Mr. Bingham signed on behalf of Whistlepunk. First deed was Snowshoe to Whistlepunk. So Mr. Bingham has the knowledge. Whistlepunk then has an out conveyance to Mountain House. That conveyance in 1981, only 2 years later, signed by Mr. Bingham, says, it refers specifically to this clause. It uses the language successors and assigns. It specifically says the thing that we all wonder about.
You have that, and you have the fact that through multiple entities, they kept giving that access to the tickets. So, I mean, if you get extrinsic evidence, that's one thing, but you only get there if it's ambiguous, right? If it's unambiguous, we don't look at that. You agree?
If it is ambiguous, you look at it. If it's unambiguous.
And the fact that two sides offer different interpretations doesn't create ambiguity. That's our job, right?
correct. Both sides saying we're clearly right doesn't mean it's ambiguous.
And you, I don't think you've made this argument, and I'm not saying you should have, but you're not making the argument, are you, and if you are, just say so, that the successor and assign language that Judge Heighten's referred to as sprinkled throughout here, are you saying that it applies to this paragraph? Or you, so it's not your position that when you say successor and assigns on, page 2, and then before this on page 3, that's referring to the paragraph at issue?
No.
You're saying we look at that paragraph and it's enough in and of itself?
That's my argument. That if you look at the deed, and look at what was intended here. Snowshoe was building a resort, a ski resort that we've been to. The purpose of selling this property back in 1979 was that so people would build hotels, people would build condos. The
And is
property
that
would
a
develop.
fact we can consider in interpreting this contract?
Well, it's mentioned in the deed. It mentions the resort. It mentions the easements to
So we
use
don't have to
roads.
worry about it being extrinsic evidence because it's in the deed?
No, Your Honor. But if this doesn't run with the land, then here's the situation we have. Property was sold. Please build hotels on the land. Please invite guests to Snowshoe on top of the mountain to the resort. And if it doesn't run with the land, Snowshoe can now forbid anyone who stays at the Corduroy Inn from using the facilities. They're
Well, hold
private
on,
land.
no. The original grantor can't do that. The only problem is the original grantor is bankrupt and gone. It's been sold like 5 times since then. No one is saying this wouldn't be binding on the original grantor. At least I don't read the district court as saying that.
I'm sorry. Snowshoe Mountain can now.
A completely different company that is operating it decades later, who bought it from a chain of people that went through a bankruptcy sale, can do it.
Correct. Who we say and have alleged that it is a successor in interest. And if you look at the records, they have acquired the property right. So the question is, going through bankruptcy doesn't remove the burdens of the land. It may make Snowshoe Company not liable for it, but the land would still be bound by this.
Is there anything to the nature of this, this paragraph, what it's talking about, ski ticket privileges, lift ticket privileges on other land? That seems different than an easement or a right-of-way or something like that. Do you, maybe it doesn't, it's not, doesn't touch and concern the land in the same way? What's your reaction to that?
This is granting a license to enter onto property.
Okay.
This covenant says, guest of this property, purchaser of resident on this property, you will have the right to enter onto Snowshoe's property under certain terms and conditions. And those terms and conditions are the same that we will offer our own guests.
Okay.
So it does touch upon the land, because you have to be a guest of a hotel, you have to be a licensee, or you have to be a purchaser. You have to own part of this piece of property to then have that right. You can't just be somebody off the street. So it touches the land. It also touches Snowshoe's land, because it is, I am giving you permission to enter onto my land and use my facilities. So I think it touches on both.
Judge Hines? Thank you, counsel. We got some time left after your colleagues' time.
Bear with me, I left my reading glasses, and the language in this deed is pretty small.
You'll need it.
That's okay, it's right here. Good morning. May it please the court. My name is Seth Hayes, and I represent Snowshoe Mountain Incorporated, the appellee in this proceeding. The district court's decision below that this is not a covenant running with the land should be upheld for 2 reasons. First, the clear and unambiguous intent by Snowshoe Company and a boss is that the burden imposed in this covenant does not pass to the heirs and successors of Snowshoe Company, as Judge Heitens commented before. And the second reason is that it can never be a covenant running with the land at common law because the burdened estate, that's the recreational facilities of Snowshoe Company, does not touch and concern the land conveyed to a boss, and a boss has no privity with those recreational facilities. That's McIntosh, Rawlings, tenant cases. But the first point I want to address is the argument that Ruby Dog makes, or the appellate makes, concerning the presumptions in this case. And a couple points here. First, presumptions are only applicable if the deed is ambiguous. If the deed is unambiguous, we never get to the presumptions. Second, appellant states that there's a presumption that all covenants in these deeds, including this one, shall run with and bind the land. The problem is, there is no such presumption in West Virginia common law.
Would you say that again, what you believe his definition of the presumption is?
I think appellant states, and we disagree with this presumption, the appellant stated in his brief is one of the points of error and in opening in his arguments that there is a presumptions in West Virginia that all covenants and deeds shall run with and bind the land. And that presumption does not exist in West Virginia common law. Appellant cites Mays v. Hogue, and as Judge Traxler pointed out, that's dealing with rights of ways and easements. Rights of ways and easements are a type of servitude, so are rights of first refusal, so are covenant. They're all different types of servitudes.
But
And
why isn't what we have here positing that it's some sort of property interest? If it's a property interest, why isn't it an easement? It seems like this is an easement, not a covenant, if it's any type of property interest at all.
Well, it's not an easement for this reason, Judge. One, we're talking about, if you look at the benefit here, it's a privileges and amenities. The dispute here is about a promotional marketing. It's discounts, discounted ski tickets, discounted lift tickets is what's at issue here. Second, they say multiple easements throughout the deed in question. I mean, there are several easements at issue here, non-exclusive easements and exclusive
For
easements.
things like power lines and things like that.
In every single instance, they qualify it as an easement, and they go one step further, Your Honor. They state that the easement shall bind the successors and heirs or inure to the benefits of one of the parties, language that's omitted from the recreational facility. And the reason that's significant is this. Mays v. Hogue, Post v. Bailey, and even the McElroy case in 2020, when we talk about easements, they talk about the common law. And at common law in West Virginia, easements are presumed to run with the law unless there is a clear intent of the parties to the contrary. But I invite this court to look at the McElroy case, which is 2020, which appellant cites. In that case, they're talking about two different types of servitudes. Now, we disagree with the proposition that McElroy stands, that is cited by the appellant, that it somehow all easements now or all covenants are intended to run with the law. Because if you look at McElroy, there's two different types of covenants in that question. Rights of way, rights of first refusal. And they state that the easements and rights of ways are presumed to run with the land at common law. But they talk about a separate type of servitude, and that's a right of first refusal. And actually, in McElroy, the court indicated that at common law, rights of first refusal are presumed to be personal. The easement, or the covenant in this question, or at issue in this, in the recreational covenant, is more akin to the right of first refusal. We're not talking about an easement, ability to go over one's property. Those are set forth elsewhere in the deed. We're talking about a privilege, amenity, access, not even access, but a promotional advertisement or a marketing effort on behalf of Snowshoe Company.
Well, let me ask you this. Going back to the point your colleague was making at the end, does your interpretation allow Snowshoe to restrict use of the slopes to only those people who are renting from them? And effectively exclude
Inexplicably exclude.
the members of the guest of Ruby Dog?
It wouldn't make much sense for a resort
No,
community
but
to sell lift tickets.
is it consistent with your view?
Our view is this. I mean, this isn't really briefed here, and it's more of an issue for phase 2. But they use, there is evidence, and it's not an issue in this case.
Seems like my question could
Yeah,
be answered yes or no.
I'm going to answer it. No, Your Honor, because the ski facilities, the ski slopes.
I got hearing aids, I'm sorry.
I'm sorry, Judge Traxler. The ski slopes, and it's the position we take in our complaint. The ski slopes and ski facilities are actually different than the recreational facilities. There is evidence, not at issue in the 12C argument here, but for purposes of this question, that they've treated ski slopes differently than they did recreational facilities. Again, this is extrinsic evidence because the parties did conduct discovery here. Again, not an issue
So
in
rights
12C.
do continue with regard to Ruby Dog's guess regarding the use of slopes.
They can use the slopes, they're not recreational facilities. Let's use.
Wait, hold on.
agreement-
Judge Traxler is asking what your view that your client could do, and you're responding by saying what your client is in fact doing. So let me ask, if your client wanted to, is it your position that your client could say, no one uses these ski slopes except guests at our resort?
Absolutely, Your Honor, they can do that.
They could do that.
They could do that. They don't do that, but they could do that.
And is that not a factor in our analysis of what our interpretation, or what the interpretation of this deed would allow?
It's not for a few reasons, Your Honor, and that's this. We have to get to the intent of the parties. The overarching principle here is what is the intent between Snowshoe
But doesn't
Company
the intent have to
and a
be
boss?
reasonable? I mean, these people, Ruby Dog's predecessors are investing millions of dollars in building a hotel. And you say, your position is, frankly, we could forbid their guests from using our slopes, which means they can't, they're gonna take a loss when they sell it?
I mean, Your Honor, it's not a court's job or when interpreting a contract to construe an unambiguous deed. We have to apply
So your
the
answer is
unambiguous
yes,
language.
and all those inequities are just the way.
That's just the
it's
way
drafted.
they drafted this deed at this time. I mean, to be clear, that's not happening.
So
But this
why-
is the clear intent of the parties
So,
is to
counsel,
limit
let me,
this. Yes, Your Honor.
I'm sorry to talk
No, no,
over
no.
you, but, under your interpretation of this deed, is every other, obligation and, benefit and burden, does every other benefit and burden run with the land except the recreational covenant?
In this particular deed, the benefits, the burden to state, which is really the critical issue in determining whether it runs with the land, does run, or there is a conveyance, there's privity and a conveyance of the burden to state within the deed itself. Yes, Your Honor.
So
Okay, I tried to be, I may
Yeah.
have asked a bad question.
No, I
'cause
apologize,
don't
not clear. The answer is yes.
Let me
I
re-
believe so. Yes, Your Honor, but
Please let me finish.
I'm sorry.
You stop and I'll give you plenty of time, just so we're clear what I'm asking. Let's say I magically put a, blue pencil and said that this recreational paragraph was not in the deed. Let's assume we got this deed absent the recreational paragraph. Would all the rights and obligations run with the land?
I believe the language of every single provision, the answer to that is yes, Your Honor, because they do state either it applies to their successors and signs, or it's intended to run with the land. The recreational covenant's the only covenant that omits that language.
So can I ask you a question that relates to that? So I understand your argument that all these other provisions say this, and it seems like a very good argument for you that all this language and its omission here probably has to mean something the way courts construe instruments. But can we just take a step back, and I could ask you a question that I was mulling with. Why would parties do this? Have you been able, and not why did these parties actually do it, but why would an objectively reasonable party might have done this? So you've created a world in which this deed has all kinds of things that run with and concern the land, and then we get to this one paragraph, and your view is that the burdens don't run with the land. What is a reason that someone might have done that?
Your Honor,
Because presumably,
first of all, it helps the boss sell these units. That's the intent. I mean, that's one possible intent. Again, overall purpose is, it's not our job when the language is clear to understand why they did or didn't do something. They made it clear within the language of the
That
deed.
may be right, but.
But sure,
is
you
there-
can. I mean, it helps a boss sell condominium units. That's one
no,
purpose.
sorry. Why might a, let me rephrase the
Okay,
question.
I'm sorry.
Why would a party have listed all these things in the deed and said, all of these things continue to burden the estate,
Right.
and then decide this thing doesn't? What is the reason why a hypothetical drafter might have done that?
Again, the answer is because at common law, this cannot run with the land. For this reason, there's two separate estates here. There's a burdened estate, which the recreational facility sits on, and a benefited estate, which goes to a boss. And if you look at McIntosh, if you look at Rawling and Tennant, we're concerned not just with the benefit estate, and whether the benefit benefits the landowner. McIntosh says, of course, the benefit always benefits the landowner. But the burdened estate is that burden state, those recreational facilities, does that touch and concern the land conveyed to a boss? In this
So
case,
wait,
it
so,
doesn't.
so the argument then would be, well, the parties probably would have liked for it to, but they thought that it couldn't, so that's why they didn't say it?
No, the argument is the drafters understood the common law, and they knew that this particular provision, the way it was set up, is a marketing promotion, basically, Your Honor, cannot run with the land at common law. I mean, Ruby Dog makes the argument that these cases are outdated, right? And the West Virginia's moved on. We disagree with that, but let's step back for a moment. This deed was drafted in 1979. The cases we cite, 1940s, 1950s, that's akin to us citing cases from the 1990s. Now, some of our law clerks might think that's really old, but I don't.
So, two questions, and, the recreational paragraph talks about, guest of the hotel and lodge, and then it talks about and all purchasers of residences, correct?
Correct, Your Honor.
So let's assume, John Smith purchased a condo from a boss. Did that, does Mr. Smith have the right to the benefits of this paragraph after Snowshoe Company sells the land?
No. He
So-
does as long as Snowshoe Company still owns the land.
That's your, okay.
All right, excuse me.
No, go.
My question's related to that. Your position, as I understand it, is that the recreational paragraph gives rights only to a boss. Is that how y'all pronounce it? A boss?
I think it's,
Okay,
your
whatever.
pronunciation
We
is the
know
same
who
what we're
we're-
using.
Okay, whatever. Do they not extend then to the lots that a boss might sell to individual purchasers?
No, I believe that was Judge Quattlebaum's question.
It may have been.
And yes,
He's
it
a lot
does.
smarter than I am, and I'm trying to dumb it down to my level.
I understand.
That wasn't a good answer to say, I understand to that. You might say, I understand.
I take that, I understand that well, your point is taken, Judge Quattlebaum. Let me answer it this way. Yes, that's the intent of the
Yeah,
parties.
wait, yes, what?
It would apply
So
to
they have rights,
the residential purchasers of
they have rights that a
condominium
boss
units.
doesn't have?
Well, it's a benefit to a boss. It helps them sell the condominium
But
units.
the answer to my question is, these individual purchasers from a boss have rights that continue under this paragraph, but a boss doesn't.
Well, a boss is continuing to sell
Is
residential
that yes or
units.
no?
Yes, I believe the answer is
Okay,
yes. That's the clear
okay.
language of the parties.
Okay,
That's interesting.
Now I'm confused. I thought you said the exact opposite to me. I thought you said that these individual purchasers' rights were the same as a boss, that once Snowshoe sold it, they had no more rights under this paragraph.
Let me make sure, because I think, apparently I'll try to be more precise with my words. The benefit, the intent of this paragraph is clear, that hotel guests, regardless of who those hotel
Who's
guests are.
hotel guest?
It doesn't limit the benefit to a boss in this paragraph. A boss is not specified. I do want to point out, the important point here is it does specify the covenanting party of Snowshoe Company. But the intent, the clear language, if we apply the clear language of this covenant, then hotel guests of any hotel constructed on this property and residential purchasers of condominium units constructed on this property shall get the same privileges and amenity that Snowshoe Company offers its guests. That's the clear language of the covenant. The key point here is we can't conflate benefit with burden. It doesn't specify a boss, as Ruby Dog points out. That's correct. It does specify Snowshoe Company, not once, but twice. It doesn't say Snowshoe Company and its successors and assigns will provide these benefits and amenities. It doesn't even say a generic owner of this resort community, like it does in the same covenant with hotel guests and residential units. It says Snowshoe Company and only Snowshoe Company will provide the privileges and amenities that Snowshoe Company and only Snowshoe Company offers its guests. Herxthal, that's the case that where the court construed a personal covenant, despite the clear intent of the parties. And in Herxthal, the court said, look, this is a personal covenant, despite what they state.
So before you talk about that case, I think I understood that answer to be that the guests transfers of residents from a boss are treated the same way.
They are, Your Honor. They're
As in,
treated the same.
they both had rights, while the entity that I'll call Snowshoe One. While Snowshoe One owned the resort, they all had rights. And now that Snowshoe One doesn't own the resorts, none of them have rights.
Exactly, Your Honor. That's our position. That's the clear language of the covenant.
So, I said a second, I got a second question, and here it is. Yeah, we're dealing with, case law on some topics that some people would say aren't, crystal clear. You may disagree with that, and if you do, that's fine. But they're state law issues. Is this something that, would make sense for us to certify to the West Virginia Supreme Court for resolution? Do you have a position on that?
I don't believe it's necessary, Your Honor, because West Virginia has already answered this question, and they've never overruled the common law. And under the West Virginia Constitution, Article 8, Section 12, maybe Section 13, West Virginia adopts the common law as existed at the time of the Constitution. We've seen these cases applying the common law of West Virginia, and the Constitution states that unless that common law is explicitly overturned either through subsequent decision or statute, the common law is still in effect. There is no cases, nor does Ruby Dog cite to any case, which states that these common law factors that we've discussed are overturned. They're still in effect. Moreover, even if you look at Ruby Dog's argument, which is the courts have sort of moved on from this, it's still a holding in those cases. What the courts focus on is the intent. Let's strip everything away. The intent of this covenant is for Snowshoe Company, and only Snowshoe Company, to provide these privileges and amenities. The second point I want to address is the argument that we should simply look at this covenant, as Ruby Dog suggests, in isolation. But that contravenes well-established deed and contract interpretation principles. When we interpret a deed such as this, courts are instructed to look at all four corners of the instrument, not just one covenant in isolation. And moreover, when you do that, when you look at the deed as a whole, you're required to give effect to all parts of that instrument and not render phrases superfluous or redundant. Here, the parties made explicitly clear every single covenant easement provision in this deed they wanted to run with or bind or inure to the benefit of one of their successors and heirs. They said so. Why? They used that phrase. And Tiffany's on Real Property tells us when you use that phrase, it's legally significant. When you use it, it's important. And when you don't use it, it's also important.
Why isn't it reasonable to say all those uses signify that all parts of this deed were intended to run with the land? And sure, I know your response is, well, that language is not in the paragraph at issue. And that may be a chink in that argument. But why is it fatal to the argument that if you look at this as a whole, they're saying this over and over, and there may have been an omission in this paragraph, but the intent is everything here runs with the land?
Because it would render those other phrases superfluous.
Well, no, it wouldn't render them superfluous. The fact that they're using them throughout the deed means they're intending for all these things to run with the land. They just happen, and if you didn't have any of those, render them superfluous would mean you don't have to say those at all. I'm making a slightly different position, that they matter. They signify the overall intent that everything runs with the land, and the fact that there's not one in that paragraph is an oversight.
I think in deed interpretation principles, and this is the Harvard case, that contravenes deed interpretation. I mean, when drafters have—
There's a flip side of that.
Yeah, when drafters have a phrase in mind, and they clearly do here, when they use it, they mean it, but equally, when they don't, they don't. And that's the Latin maxim, expressio unis est exclusio alterius, and I'm sure I butchered that. My Latin teacher would be very disappointed. I didn't have Latin here. But the maxim is you expressly mention one thing that implies you intentionally omit the other.
Okay. Any other questions? Do you have any questions?
Thank you, Your Honors.
I will be very brief. The hypothetical that you ask, Judge, I think is very telling, which is, why would any reasonable person have a personal covenant that only Snowshoe Company is bound by and only a boss gets the benefit of in a situation where we're trying to develop a resort and convince people?
Well, wait, hold on. Your friend on the other side's position is not that only a boss. As we eventually clarified, his position is only Snowshoe One is bound, but everybody else benefits as long as Snowshoe One still owns it. That's the hypothetical covenant we're talking about here.
Okay. Why would anyone agree to that? Well, first, I mean, the district court didn't base its decision upon that. In the appendix 506, Snowshoe Mountain admits that they acquired any real property interest held by Snowshoe Company. But more importantly, your hypothetical, let's take it just one slight step further. Snowshoe One develops the resort. Snowshoe One sells property to a bunch of people and says, please invest millions of dollars. And you do. And then Snowshoe One sells all their interest to Snowshoe Two in 1980, 1 year later.
Or
And then
the
takes
next day.
Or the next day. And then takes the position, nobody but us can use the resort. Nobody but our guests can use it. Snowshoe Company had the duty. One had the duty. Snowshoe Company 2 now exists, and every guest can't use our facility. What's going to happen? Well, now we have a fire sale, because people have built condos on a mountaintop resort that's a ski resort, and you can't have your guests ski.
So if that, I mean, I hear you, but are we supposed to interpret the deed like that? Let's assume we say, as a matter of black and white contract, that's what this deed says. You disagree with that, I get that. But let's say it unambiguously says, this only is an obligation for Snowshoe. And there's no other way to read the agreement, but that it has that harsh reality that you articulated and Judge Traxler articulated. Are we supposed to consider that harsh reality?
I think you're trying to figure out what is the intent of the parties.
So,
That's the polar star, that's what.
but if the best intent is from the language that the parties agreed to, and it's clear as clear could be that this only applies to Snowshoe Company, it seems like you're asking us to look outside what is written, at least in this hypothetical, and say, well, no one would do that. Well, in the hypothetical, they did. It's clear. And you're looking to, like us to, I think, maybe fix the harshness or of the terms.
I think what I'm trying to, and maybe I'm not doing a very good job of it, is to say that that harshness shows that that couldn't have been the intent. That the language of the deed, the language of the covenant, clearly establishes that the parties thought this ran with the land because it goes to purchasers. It has to run with the land if it goes to purchasers. They also had to have believed that Snowshoe Company.
You've said that now several times. I don't
Okay.
know why that's true. In order to go to purchasers, all it has to do is bind the original grantor as a matter of contract. Why does it have to run with the land to go to purchasers? Why isn't it just a contractual promise of the original grantor?
It doesn't say purchasers from a boss. It could be purchasers on down the chain.
Sure.
And so, again.
That just means people can assign their contractual benefits multiple times. I can have a contractual obligation to pay you, which you assign to her, which she assigns to him. And I'm still bound to pay him.
Correct. Except for the difference between what you're suggesting and what I'm suggesting here is this is in a deed. This is a document which transfers interest in real estate with the presumption that it follows the land.
Can I
With
ask you
the
a couple-
presumption that a personal covenant must be clearly stated. And it's not here clearly stated. So if we have a question, what's clearly stated, and we have this vacuum, arguable vacuum, then we come down on the side of it runs with the land.
So I have a couple of questions about certification because it came up. Which party decided this litigation was going to be in federal district court?
The plaintiff was Snowshoe Mountain.
Who removed this case from state court to federal court? That was your client, right?
That's correct.
Did you ever ask the district court to certify before you lost this case before the district court?
Neither party asked for
So
certification.
that's a no? And
That's
have
a
you
no.
ever asked us to certify this case to the court?
I have not, Your Honor.
One question before you finish up. West Virginia courts frequently cite to the restatement on property. Isn't it a factor in determining the intent of the parties whether or not a large investment is contemplated by the grantee buying the property?
I think that you look at all the circumstances, including the surrounding circumstances to the deed, the investment, what was the intent of the parties, and clearly the deed references not only Snowshoe Company, it references Snowshoe Resort. The easements for the roads, you can use the roads to go to Snowshoe Resort. You can do this for Snowshoe Resort. It contemplates that this is a development as part of Snowshoe Resort, not merely just this little piece of property. You can use our roads. And one last point, if I may, the question of the use of successors and assigns is actually when things are granted to the grantee, successors and assign language is not used in description of Snowshoe. Now, indicating that the parties did not think that you had to use successors and assigns to make it bind and run with the land, because clearly the covenants that are listed do run with the land.
Thank you, counsel.
Thank you.
We'll come down and greet counsel. Okay, and we'll proceed to the third case after that. Okay, we're here for our last case, 24-1536. Is it Mr. Gloss?
Yes, Your Honor.
Okay, we'll hear from you now.
Thank you, Your Honor. May it please the court. Again, this is Peter Glaus for the appellant, Mr. David McKay, in this matter, who's in the courtroom with me today. Your Honors, the errors by the district court below require this court to vacate the judgment against Mr. McKay for breach of fiduciary duty as a director and officer of Mona Electric Group, Inc., which is also referred to in the briefing by its acronym MEG, or MEG. Two of those errors: one, the failure to enforce a release of claims, and two, the lack of any duties occurring after the sale of the company, viewed together warrant an order that directs entry of judgment in Mr. McKay's favor. But at a minimum, Your Honors, all of the errors that we have briefed, including flawed jury instructions and improper evidence, in their own right, require remand for a new trial on this particular
Can I start
claim.
with a question about the release?
Yes, Your Honor.
So if this release barred the fiduciary duty claims at issue in this case, can you give me an example of a claim that wouldn't be released by the SP? I've been trying to contemplate, like, I agree, this is a broad release, but I'm trying to figure out, it would be helpful to me to identify a type of claim that you think would not have been covered by this release.
Yes, Your Honor, and actually such a claim was brought in the case.
Okay.
There were 4 causes of action, one of which was breach of contract. And the contract was called a transaction bonus agreement that was pre-purchase, but was incorporated into the stock purchase agreement as a transaction document, right? And so...
And that's not released?
No, Your Honor, because there's a kind of introductory language in the release that exempts, that carves out the SPA itself, obviously, or transaction documents. And so Mr. Mona, the appellee here and the plaintiff below, alleged that a lot of the same, or in fact, all of the same conduct that encompassed his pre-purchase breach of fiduciary duty claims also constituted a breach of that contract, the transaction bonus agreement, which was count 1. That went to the jury, and Mr. McKay prevailed on that claim. So,
Okay, but that gets you somewhere, but I guess my one concern would be to say, so you say it's covered by the introductory clause.
certainly.
Okay. Can you give me an example of a claim that is not covered by the introductory clause, but is still excluded?
Well,
And
certainly.
the reason I say that is because if the number is a 0, then this could be a heck of a lot shorter. It could say, other than the things covered by this introductory clause, comma, everything on earth is released. But it doesn't do that. It lists a whole series of things, which implies to me there's some universe of things that's not covered by the introductory clause that is still not covered by this release.
Any obligation that would be arising out of the contract itself. I think it's meant to be fairly specific, Your Honor. I mean, obviously, a rescission claim wouldn't be.
Well, then this clause could have been a heck of a lot shorter.
It could have been. I didn't draft it, Your Honor.
Fair.
Maybe it should have been, but it's
Or
not.
it would have said all claims including but not limited to this big long list. It just seems weird that you would say this big long list when what you really mean is everything in the world not covered by the introductory clause.
Repeat that, Your Honor. I'm not.
It seems to
following.
me that unless you can give me an example of a claim that is not covered by the introductory clause,
Correct.
but is still not released, then you are essentially asking us to read this clause as if it said, excluding the following, comma, everything on earth is released.
That is how I think a reasonable interpretation of the clause is.
It seems to me that if a reasonable person who meant to say that would have said that rather than given a big long list.
Well, here in this particular clause, as applicable to this case, you have some very specific language that I would like the court to focus on, especially the language that states, and just for reference, Your Honors, the release is on pages 5040 to 5041 of the joint appendix. It states that without limitation, the release includes claims that arise out of Mr. Mona's status as a former shareholder of the company. When we're looking very specifically at the claim that's before this court, breach of fiduciary duty against Mr. McKay as a pre-sale director and officer of the company, I think clearly the only way that Mr. Mona could have brought that claim was under his status as a former shareholder of the company. There's simply no director and officer fiduciary relationship before that. So although we may look at this in the abstract and say, well, what claims might be carved out, what claims are not carved out here, you call out the very claim that the court allowed to go to the jury in this case, the pre-suit fiduciary duty claim, that clearly should have been released and should have been ruled on as a matter of law. Your Honors, I'd also like to touch on the post-sale period quickly, unless there are further questions on the release. The post-sale period starts the day after the stock purchase agreement is signed on February 1st, 2020. Another critical aspect of that agreement is Mr. Mona's representation and warranty that he would produce the resignations of all the directors and former management of the company, which would include Mr. McKay. So Mr. McKay accordingly resigned as a director and officer of MEG on that same day. Here, the district court allowed the presentation of evidence and a finding of liability based on post-sale conduct when Mr. McKay was neither an officer or director of MEG. No Maryland court or any federal court interpreting Maryland law has ever expanded director and officer liability in the manner allowed by the district court in this case. And this is particularly true, as I mentioned, when Mr. Mona himself knowingly and intentionally severed the fiduciary relationship with Mr. McKay as part of the stock purchase
What
agreement.
about a provision requiring confidentiality with regard to matters involving the contract? That obviously would extend past the consummation of the deal.
A provision in the
So
contract.
are you arguing that you can never have there's no such thing as a breach of fiduciary duty after a sale is completed?
A provision in
With
the,
regard to a director or
in the provision in the contract itself, the purchase agreement itself that require confidentiality?
I'm just wanting to know, are you saying no responsibility can continue after completion of the sale of the company with regard to a officer or director?
For specific issues like confidentiality?
Never mind.
It's
Well,
possible.
let me give an
It's
example that
possible.
occurred to me.
He's gonna make my question sound
Yes, sir.
smart.
I'm not sure that's going to be the case. I will do my best to make my own question coherent. So it seems to me that before I became a judge, I was a lawyer and I represented clients.
Yes,
and
Your
I
Honor.
had a fiduciary relationship with them, and my former clients told me things. They're not my clients anymore, but I guess I have assumed that I am still bound by my duty of confidentiality to my former clients, even though they are my former clients. That's true, right?
Without question, Your Honor.
Okay, so that suggests that certain fiduciary obligations survive the ending of the fiduciary relationship. At least some must.
So long as they arose before the ending of the fiduciary
Sure,
relationship.
right.
And I think that's the key here, right? The duty of confidentiality would be a duty that originates during the fiduciary relationship and clearly must continue as a matter of law, or else the fiduciary
Because
relationship.
every fiduciary learns all kinds of things in the course of their fiduciary relationship.
Correct, or else it doesn't mean a whole lot.
Right.
So if we're talking about confidentiality, that may be an exception to a general rule that fiduciary duties end when the fiduciary relationship ends. So no, Your Honor, I would not argue that there cannot be any world in where any obligation can't continue.
And then okay, so let's go one step further out from confidentiality. The first duty is to not blab your client's confidences. The second is not to use information you learned in your capacity as a fiduciary to harm your client, right? It's not just that I can't blab what my client tells me. I can't use the information my client tells me to the detriment of my client. So, during the fiduciary relationship, I certainly cannot use information my client tells me to the detriment of my client, right?
Oh, absolutely.
Even if I never tell anyone, I
Correct.
just hold it in my head and go do things in the world, right?
Correct.
So why doesn't that obligation also survive the ending of the fiduciary relationship? To not take information you learned as and when you are a fiduciary, to then use it to harm the client after the fiduciary relationship is over.
That seems that it would be an intentional tort beyond simple breach of fiduciary duty.
But breach of fiduciary duty isn't intentional.
It can be. It can also be a negligent tort, and here, the allegation was negligent breach of fiduciary duty, Your Honor. And the specific conduct at issue post-sale was really just Mr. McKay acting as an employee, allegedly in a manner that didn't benefit the previous owner of the company. And so here, to hold that Mr. McKay, and before I go, I wanted to address Judge Hasten really quick. Because when we're talking about lawyers, it's a little different, I think, than when we're talking about an employee of a company. Because the employee of a company is always going to have an obligation to act in the best interests of the company. And if ultimately, after the purchase and sale transaction and acquisition, if that isn't necessarily in the best interest of the previous owner, I don't think it's a very good analogy to look at it in the lawyer-client context and the employee-employer
So that's-
relationship.
You bring up an interesting point. Your client became an employee of Archkey.
Of Meg, Your Honor.
Okay, Meg, I'm
Yes.
sorry, of the entity, so I don't mess up the names. Presumably had some duties of loyalty to that company.
More than presumably, I think, admittedly, yes.
Yeah, so, yeah, he may have been in a tough position, right? I mean, if is the fact that he had duties to his new employer, does that mean, as a matter of law, he doesn't have duties to someone else? I mean, you could, for example, lots of people are warned not to put yourself in a position where you have conflicting duties.
Correct.
That's a bad deal for lawyers, that's a bad deal for other people. You may not always realize it at the time, but with the benefit of hindsight, having conflicting duties can be maybe a problem.
Well,
Why don't we have that here, where Mr. McKay, as an employee, had certain duties, but he had, his fiduciary relationship may have terminated, but some of those duties that arose pre-closing continued.
Well, here, Your Honor, I think we need to look at it in the broader context of the complete separation of essentially the parties as part of the stock purchase agreement. I mean, you have a document that is extremely lengthy, that has both the release representations and warranties, and other various aspects that show a clean break here. And so when you're in the business world, the corporate context, as we are here, you can address those by contract. And that's the whole purchase of the stock purchase agreement. And the very point of securing the resignations of the pre-sale directors and other management of the company.
Does your client, and I'm not saying these equal fiduciary obligations, may be more promises or things of that nature, but it seemed, I mean, does your client contest that it had a duty to attempt to maintain the workforce and the culture of the company?
Yes, we did contest that, and that.
You contested whether that was a responsibility of your client?
Yes, we did, and that was a key aspect of the contract claim. And so when we're talking about what I think is the real differences between fiduciary duties and, well, can any kind of running of the business nature duty exist? If it's part of the contract and it's worked into the SPA, then the answer is unequivocally yes. That claim was brought, tried, 17-day trial, and the jury found in favor of Mr. McKay on that claim. And so there was no, there was an avenue of recovery, but the jury didn't agree with it. The fiduciary duty claim post-sale was not appropriate because it improperly expanded the duties beyond what I think Maryland law, or to be honest with you, Your Honors, any case that I've been able to find. I could not find a case, nor has my colleague in opposition cited a case where a corporate manager's fiduciary relationship and duties continue to a pre-purchase shareholder in the same way as here.
I'm sorry, I'll make sure we get that. But did you, before us is, to the extent the award involved, assume we have the jury verdict pertained to pre-closing duties.
Yes, Your Honor.
I know you have an argument about, did you challenge the sufficiency of the evidence in terms of conduct, whether it would amount to a breach of fiduciary duty?
Yes, we did, Your Honor.
How? I'm not sure I...
Well, in terms of the sufficiency of the evidence?
As to, to the extent, my question assumes the verdict relates to pre-closing misconduct.
Well, we don't know what the verdict relates to.
I understand that. I understand you have a separate argument on that, and I'm not asking, this isn't like a harmless question.
Correct.
I'm just saying if we zero in on the claim when he was a fiduciary, pre-closing, I didn't see, and I may have misunderstood it, that you said there's no evidence from which a reasonable jury could conclude that he didn't violate his duties pre-sale.
That's not an aspect of the appeal, Your Honor.
That's what I was asking.
No, so that's not before the court. That was before the trial court, but we have not pursued that particular issue on appeal.
So can I take you to a question with the attorney-client privilege issue?
Yes.
So the parties both seem to assume this is federal privilege law. Why isn't under federal rule of evidence this an issue of state privilege law?
When you speak of...
the privilege,
on
or
the
whether the attorney-client privilege and whether attorney-client privilege was waived, all the cases you're all citing seem to be federal cases that assume this is federal privilege law, but it seems to me that the last sentence of Federal Rule of Evidence 501 says any attorney-client privilege issues in this case are governed by state law and not federal law.
I think that is a state, when we're talking about the evidentiary waivers, Your Honor,
Yeah.
that we've briefed.
You're all citing federal cases, and no one tells me what the relevant state law says.
Your Honor, they're federal cases interpreting Maryland state privilege law. Yes, it would be.
And you think it's Maryland law? Because it says, if the state for which the state law supplies the rule of decision. What is
Yes.
the state law that supplies the rule of decision for purposes of these privilege issues?
Maryland.
Maryland?
Yes, Your Honor, because MEG was a Maryland corporation, operated in Maryland, and Maryland law would clearly apply to the privileges at issue. Your Honors, if I could move very, very quickly, as I'm running short on time, to the jury instructions here. The verdict form contained, as I mentioned, separate lines for director and officer liability. but the district court gave a single overly broad instruction as to officer and director duties. As to director duties, I think it's pretty clear that the jury instruction was overly broad. Director duties are very specifically defined in Maryland statute at section 2405.1 of the Corporations and Associations section. 3 duties, Your Honors: good faith, reasonable belief in the best interest of the corporation, and an ordinary prudent person standard. More importantly, however, is subsection G of that code that mandates a presumption of good faith. By disregarding the statute and instructing the jury that Mr. McKay could be found liable as a common law fiduciary, the district court failed to fully and correctly inform the jury on director and officer duties and the presumption of good faith. On officer liability, although the statute speaks only to director liability, the case law in Maryland and elsewhere, and especially Delaware, which Maryland looks to for corporate law guidance, applies the business judgment presumption of good faith in favor of officers as well. And there's really no reason why Mr. McKay, in his status as a director officer, should not have that same presumption, and it should have been disregarded. It should not have been disregarded by the district court. Your Honors, I know my time is done. I'm over time. If you have any further questions, if not, I will reserve.
Thank you.
Thank you.
We'll have some more time in the rebuttal.
Thank you.
Good morning, and may it please the court. Let me begin where Judge Quattlebaum's last question was. Is there a challenge to the sufficiency of the evidence? The answer is no, as Mr. Glaus recognized. That's not before this court, but I think it's really important to keep this in mind. After you weed through all of the arguments that Mr. McKay is advancing now, what you don't find is that the evidence of his pre-sale breaches of fiduciary duty was lacking. That when Mr. McKay was on Cap's time and on Cap's dime, he didn't breach his fiduciary duties. He did so in several ways. He channeled the sale efforts towards Archkey for self-interested reasons. He disclosed confidential insider information about Meg to Archkey. He mischaracterized competing offers.
So that's, I mean, I don't mean to cut you off.
Sure.
I think I can tell where you're going. Quite frankly, I might contest whether at least the phone call is something that a reasonable jury could combine, could conclude is a breach of duty. But maybe there's enough conduct there where a jury could. The damages award here, I mean, we don't know for sure where it came from, but in trying to kind of make sense of where a $2 million award could be, the place in the record that it seems most likely is the delta between the amount of the hospital reserve and the settlement. It's not exactly, but does that damage award, combined with the note 5, give us a pretty strong indication, along with the defense verdict on the claims that your colleague talked about, that what this jury did was found a breach of fiduciary duty for the post-sale conduct, and frame that issue of whether that duty continues or not to us.
Thank you. I appreciate the court's question. I think the answer is no, however.
Okay.
I think there was more than ample evidence of damages that you can tie to.
What's the evidence that was put out there that would support a $2 million verdict?
So for one, the jury heard evidence of attorney's fees. The jury heard evidence of the transaction bonus, which those two figures came to approximately $2 million, most of which I'll say were not mine. I think there was more than ample evidence. There was lots of evidence about the competing offers I mentioned and the different offers that have been put on the table and that Mr. McKay did not fully and squarely disclose to Mr. Mona. And so I think I appreciate the court's question and why one might see, say, oh, well, this is $2 million, therefore that's it. I don't think that's correct. There is some mystery there. That is part of the jury process. We never exactly know. And I think that's an important thing to remember here. We are here after a month-long trial before the jury, after post-trial motions before the late Judge Massetti. You know, there is a lot of water under the bridge, and that's why the standards of review are what they are. So I appreciate the court's question on that point, but there is more than ample evidence. And in fact, this was briefed post-trial, and we spelled out several different ways that the jury could have reached that $2 million
But
verdict.
is that the question? So let's posit that I agree with you, for the sake of argument at least, that the evidence of pre-sale conduct is sufficient to support the jury's verdict. But the jury was also told it could consider post-sale conduct. And if the jury considered, so if we posit that post-sale conduct is legally erroneous, I know you don't agree with that, but for purposes of this question, posit that that's true. Then the question isn't, so then we basically have the jury's given two theories, one's valid and one's invalid. It returns a verdict that doesn't tell us what theory it adopted. If we're trying to decide whether the invalid theory was harmless, we don't have to just ask, was the evidence sufficient on the valid theory? We have to say, are we quite certain the jury would have reached that verdict on only the valid theory? And that's not a sufficiency question, right?
No, I agree with that, Your Honor, and I would answer in a couple of different ways. First, we're coming at this with the benefit of hindsight. There were 4 counts submitted to the jury, including the fraud count, which easily went before and after. I don't think that it's this court's role to look at things. It is always this court's role to look at things from hindsight, but to look at what was presented to the jury when you're weighing. Let me try to enunciate that better. When you're looking at the jury instructions and whether they were sufficient and legally appropriate, the question isn't, well, knowing what we do now, would the instructions have been given
This comes
differently?
up in criminal cases all the time. Judge Quattlebaum and I were on one a year or two ago where there's 2 theories of liability submitted to the jury. An appellate court later concludes one theory was legally appropriate, one theory was legally invalid. I mean, I get it. We can't, but we have to do the best we can. The question we have to ask is, are we quite certain the jury would have reached the same result had it been given only the valid theory? And that's not just a sufficiency question, right?
I agree with that, Your Honor, and I think we are quite certain. And let me also say the questions that Judge Traxler and that Your Honor were posing to my friend on the other side, aren't there duties that continue? So to this validity question I'd like to address, absolutely there are fiduciary duties that can continue. Judge Traxler, you identified the duty of confidentiality. Corporate opportunities are another one that will continue. The fact Judge Hayden's...
You're saying this, are you saying it based on authority that you could point us to?
One case that I would point the court to, we cited the Today Homes out of the Supreme Court of Virginia. I recognize Virginia law is not applicable here, but the proposition there, and that's a decision of your colleague Judge Agee, back before he joined this bench, that recognizes that...
So what's the fact pattern there? What's the thing that the person did after the breach of fiduciary duty that was held?
It was more akin to corporate opportunities, that the corporate opportunities that the former, I believe it was an officer in that case, or an employee, continued and
So it's an opportunity he
them.
learns about when he's an employee. He stops
Absolutely.
being an employee and then he seizes it for himself? Is that-
Absolutely. And so it continues past. And so it's well settled. And what you see in that case and the cases...
What do you do about this situation where if hypothetically or generally there can be post-sale fiduciary duties that continue? That's the big point of debate. But let's assume we agree with you hypothetically. Here, Mr. McKay, everyone agrees and it was understood that he was going to work for the company after. In fact, your client wanted him to and wanted him to do things like preserve the culture and make sure people don't get fired. But in going to work for a company, that creates legal obligations to not do harm to your employer, right? So could he, in your view of the world, comply with his obligations to his new employer and also comply with what you say his obligations were in the settlement of that hospital matter?
Judge Massetti identified the exact conundrum that Mr. McKay put himself in. He put himself in a situation where he had to answer to 2 masters. And that's not something...
At the insistence of his former master. It's not like he just did this.
Well, I appreciate that, but, he did have this information. He did have a duty.
So I guess your answer is, to my question, you no, he can't fulfill the duty that you say he had once he went to work for, the company.
I don't know
Agree with
that the answer is that he can't. I know the answer is that he didn't. In this case and on the facts of this case.
Is it, okay.
What one could, there are certainly circumstances where the interests of the new employer and the former may not be directly at odds.
So can I ask you the flip side of the question that I
Sure.
started with your colleague? What's an example of a kind of claim you think this did release?
I couldn't name, I'm sorry.
I don't mean the claim that you brought here. Of
No,
course
no,
you didn't,
I-
but give me an example of something that as a result of this
Yeah.
release.
So for instance, and I apologize, I'm getting ahead of myself
Yeah.
and mixing my thoughts here. The type of claim, for instance, if we discovered today that Mr. McKay, or let's even assume we were within limitations in Maryland, if we discovered today that for 10 years prior to the sale, Mr. McKay had been embezzling funds, that claim is probably released because it doesn't relate to the stock purchase agreement and the transaction evidence thereby. And so the key here is that the claims relate to the stock purchase agreement and the agreement culminating there. Mr. McKay's primary case that he cites on his release argument is the Parfee case out of Delaware.
Okay, so same follow-up question I asked your friend
Sure.
on the other side. Bracket that language. What claims after the words, the comma, did you release? Because again, I'm looking at it right now. This is JA 5040. Excluding in all instances any claims related to or arising out of this agreement, sell, and then comma, and then it releases a whole bunch of claims. And the question I said to him is, it doesn't say all other claims, so give me an example of a claim it doesn't release, but it does release a whole bunch of other claims besides those relating. So what's an example of those that it releases?
So I think the example I just gave would fit that, if I'm not mistaken.
Okay, because that one's not related to. I see what
Exactly,
you're saying.
exactly.
Okay,
And that's the
thank you.
point. And the reason I started talking about the Parfee case is
So
there.
Your point is, if, they want a clean break, and if there was misconduct that kind of was part of this purchase, which they're.
We're wiping the slate clean.
Yeah.
Sure, sexual harassment claims, you name it. Any of the many types of things that one sees, that has nothing to do with this transaction, with the conduct that Mr. McKay took with respect to this transaction. And so that's really it. I think the way that Judge Massetti put it was spot on, stating, among other things, the evidence showed that in selling Meg, which culminated in the execution of the XPA with Archkey, McKay disclosed confidential and unfavorable insider information about Meg to Archkey. The very contracting party, it was the beneficiary of these breaches of fiduciary duty. And so it absolutely, and the very broad language relating to, Supreme Court has recognized this court has recognized this, Delaware courts recognize this as very broad language.
So going back, but beyond the release, I just want to make sure I understand where we settled with respect to the post-sale duties. Based on the hypothetical in the case that Judge Heitens referred to, do you agree, it sounds like you're acknowledging that sufficiency of evidence on the pre-sale duties wouldn't be enough to say it's harmless if you assume there are no post-sale duties. Do you need to prevail on the proposition that there are post-sale duties here that apply in order for us to affirm the district court?
I think I see where the court's coming from with the question. I think the answer still is no. I think the fact of the matter is.
But how can you say no based on what maybe I'm misunderstood?
Well, sure.
I mean, I can see you saying no because there's a pre-sale duty and there's sufficient evidence. If that's your argument, that's got, I think, some precedential problems, so.
I think the answer to the court's question is when we're talking about jury instructions and what's required, it is not necessary to get into the absolutely super granular detail that McKay's now arguing. And I think the question is, go ahead, I'm sorry.
Isn't it fair enough that you may or may not have to go into granular detail, but does there have to be a obligation of Mr. McKay post-sale, a fiduciary the obligation post-sale for us to affirm the district court? Whether or not putting aside whether it was perfectly articulated or whether it was handled with a note and all that sort of stuff, but just as onto that matter, does there have to be a legal obligation post-sale for us to, ultimately affirm?
I don't think there has to be. I think there was in this case. And I also think, again, we're talking about jury instructions and what is expected of the trial court at that time.
And what is expected of the trial court is to correctly state the law. So if the law is post-sale conduct can't be a breach of fiduciary duty, then those instructions are a legal misstatement of the law.
I appreciate that point, Your Honor, but let me just say, even Mr. McKay's proposed verdict form included a post-sale fiduciary duty questions. The court rejected that, and I think properly, because it became an unimaginable thicket, and I can't imagine any circumstance in which the jury could have gone our way based on that verdict form, proposed verdict form. But I think the point is, even at that time, Mr. McKay recognized that post-sale duties existed.
But your answer seems to be there is a post-sale duty. So it seems like you are not wanting to say yes, but you kind of have to say yes.
I'm not trying to be evasive at all, Your Honor. I think the question is, did the jury instructions that were given accurately state the law?
Okay, so how about this? Complete the following sentence. Even if allowing the jury to consider post-sale conduct was legally erroneous, comma, we conclude any error in doing so was harmless because.
I appreciate now I'm spinning in circles to your question about sufficiency of the evidence and that being different. I think the answer is here,
Wait, so you're telling me you can't complete the following sentence?
I think, I guess what I'm trying to recognize there, Your Honor, is because there is extensive evidence of the pre-sale breaches.
And we conclude that it's not, this isn't a criminal case, so it's not a Chapman beyond a reasonable doubt. It's the civil harmless error. We conclude there is not a substantial risk that the jury's verdict would not have been the same, something civil harmless error standard, basically.
Based on the evidence in this case, I think that's right. And so I recognize where the court's going with that.
You had started to mention Parfee. Parfee seems on its face to be a bad case for you. Can you explain to me how you have us distinguish Parfee?
Absolutely. Parfee is distinguishable in a number of ways. One, that's an arbitration case. And I appreciate that the principle surrounding construction of arbitration provisions, is treated often as the same as all contracts. Every head note in that case is arbitration. Let me also.
So West's head note dictate our decisions?
Not at all. I think they follow Your Honors, but I think it's worth some recognition in terms of what that case stands for, how it's been cited also by Delaware courts. I think it's the Majowski case that Mr. McKay cites. Same thing, just for arbitration. The point is this. When our telephone provider has to sign an arbitration agreement relating to the services that they're providing us, and then one of their employees drives over our mailbox on their way to and from wherever, that claim about the mailbox, that's not subject to arbitration.
Well, hold on. Do you do any Federal Arbitration Act work?
I do.
So here's my concern, though. If Parfee is an arbitration-specific rule, it violates the Federal Arbitration Act. And the only way that it doesn't violate the Federal Arbitration Act is if it's not a rule that singles out arbitration agreements for special treatment.
So Parfee, first of all, is a Delaware case.
The state courts are bound by the Federal Arbitration Act.
Yes. Let me just say this. So Parfee, the question at issue was whether the specific fiduciary duty claims were bound by the arbitration agreement.
Right.
The court held that those claims existed separate and apart from the arbitration agreement, that there was no reason to bring them in arbitration, and it guarded the role of.
I thought you were going to lead off with this. If I recall, the agreement there didn't have the relating to language.
That is absolutely correct. That is absolutely correct. It was not a relating to.
Is that a better argument than just that it's arbitration versus the other?
That is a very compelling argument, Your Honor. It is not the same language. It deals with arbitration. It deals with a very different issue. I see that I only have 2 minutes left, and so let me just address some points of Maryland corporate law that I think McKay has just misstated. First, Section 2405.1C, I know that's a mouthful, of Maryland General Corporation Law creates a statutory standard of conduct for directors only. That dates back to 1976 when the Maryland General Assembly adopted only for directors the Model Business Corporation Act. It only relates to directors.
So what do I say about Golding?
Golding, absolutely. Golding is simply wrong for a variety of reasons.
I don't think it is open to this court to say that Maryland's highest court is wrong about Maryland law. I think that violates the first rule of Erie Railroad versus Tompkins.
This court should look to Eastland Food versus Micaiah. That's a 2023 case from Maryland's highest court, from the Maryland Supreme Court. That is the case that very clearly says, and I'll quote it, Section 2405.1, quote, does not therefore apply to stockholders or officers acting in their capacity as such.
So the argument would be that Golding has some overbroad language that Eastland claws back.
Golding is dead wrong on its face.
Well, again, I don't think it is open to us to say that Maryland's highest court is wrong about what Maryland law is.
I appreciate the humility, Your Honor.
No, I literally think it's a violation of Erie Railroad versus Tompkins for us to think that Maryland's highest court is wrong about Maryland law.
I agree and understand, but I would parse the decision. The decision points to the Black versus Fox Hills case, deals with directors only. The decision cites Section 2405.1, expressly only directors. The decision refers to the Parrish case from, I believe, the 20s or 30s. That's a director derivative case, only directors. So I appreciate what the court's saying about not wanting to second guess the Maryland Supreme Court. The answer is the court doesn't have to. Look to Eastland Food. The other proposition you'll see in Eastland Food is that the Maryland's business judgment rule is just the combination, the interplay between subsection C and subsection G of Section 2405.1. There is a presumption. That presumption, and very clearly in Eastland Food, the court says, I see my time is up if I may. In Eastland Food, the court very clearly says it's just that, it's a presumption. There's no indication that a heightened standard is required to go back to rebut that presumption. All you need is some evidence. And what evidence? There's no question about this. Evidence of self-dealing absolutely rebuts the presumption, and we absolutely have that here. I'd be happy to answer any further questions that the court has.
Ms. Heidens. Thank you, counsel.
Thank you very much.
Thank you, Your Honor, and I will be brief because I went over time on my original argument. But I wanted to address just a few points raised in the opposition. And one relates to the release. I think to interpret the release in the manner that Mr. Mona advocates would require the court to both ignore and essentially strike the very specific language that we discussed, that it includes, quote unquote, without limitation, all claims arising from Mr. Mona's status as a pre-sale shareholder of the company. And first of all, that does not conflict with the carve-out that's been the topic of conversation. But even if the court views a conflict between this very specific language that releases the pre-sale claims and the carve-out, it's basic contract construction that when you have a conflict between general and specific language, the specific governs. So here, there's no reason why the fiduciary duty claim shouldn't be released. The district court below found that there was no ambiguity in favor of Mr. Mona, that of course this claim can't be released, but it can only do so by ignoring language to the contrary. So at the very least, if there's a conflict between these and the court is not going to give preference to the specific language, there needs to be some factual findings about what the parties intended the scope of this release to be. And we sought that before the district court, and we actually asked for a jury instruction about the applicability of the release.
Your position is that it's ambiguous contract and we should do stuff, that there should have been an inquiry into the intent, extrinsic evidence?
Well, my argument is that it's not ambiguous, so that it unambiguously releases Mr. McKay for the breach of fiduciary duty claim.
I thought you said, and your colleague says it's unambiguous, and y'all just have conflicting views of that. If it's unambiguous, the district court interprets it, and and we review it de novo, right? We don't look for factual findings. It's a matter of law.
Correct. Looking at this de novo, you can't come to the conclusion that it unambiguously does not apply to the pre-sale breach of fiduciary duty claim. when you have that exact claim called out in the clause itself. Your Honor, if I could also address the discussion about Golding very quickly. There is no indication that Eastland Food sought to change the holding from Golding. And nor
How
is.
is that the holding? I mean, I agree.
Excuse me,
That one sentence in Golding is very good for you, but I read that just seems like stray over broad language.
Correct, Your Honor. I'm sorry. It was not the specific holding in Golding, but that language in Golding. That has never, and that's a fairly old case. The year is not at the forefront of my mind, but it has never been questioned by a Maryland court, state or federal.
Has it ever been extended by a Maryland court, state or federal?
I don't know, Your Honor.
Like applied or, I mean, the statement itself in Golding seems like it was obviously, did anything in Golding turn on the question of whether or not officers are protected by the business judgment rule?
No, I don't think so, Your Honor.
And has that language, I won't say holding, dicta, has that language ever been applied in a case where something turned on whether an officer was protected by the business
I
judgment?
don't know, standing before Your Honor, but I do know if we're looking to kind of for guidance on that issue, given what I think is probably a lack of guidance from the Maryland courts. Again, if we're looking to Delaware, which every Maryland court says we're going to look to Delaware to interpret, to fill in the gaps here in Maryland corporate law, Delaware judicially applies the business judgment presumption to officers, and that's not statutory. That's at common law. And we never argued, and I don't argue today, that the statutory director duties are applicable to officers. It's a common law business judgment presumption that Golding notes, at the very least, applies to officers, has not been called into question, and frankly, is very commonly applied to officers both in Maryland and Delaware and elsewhere. Thank you, Your Honors.
Thank you, counsel.
Thank you.
We're good. We'll, if the clerk can adjourn court for the day, and then we'll come down and greet the council.
This honorable court stands adjourned until tomorrow morning at 9:30. God save the United States and this honorable court.